Hey, good morning. I would like to convene this meeting of the December 11th and 12th Water Resources Commission. We will be starting out with introductions this morning, and I'll start at my far left. Jan.
Yes, Jan Lee from the Northwest region.
Janet Newman from West Side at Large.
And Julie Smitherman from the Southwest region.
Kathy Kahara, East Side at Large.
Joe Mall, West Central.
Woody Wolf, East Region.
All right. Thank you, commissioners. We will be moving into an executive session here shortly, but I'm going to turn it over to Attorney Jesse Radcliffe to start us off.
Yes, thank you. Good morning, Vice Chair Smitherman, members of the commission. My name is Jesse Ratcliffe, for the record, with the Department of Justice, acting as legal counsel for the Water Resources Commission today. So very briefly, the purpose of the executive session is to discuss the East Valley Water District storage application. This is an application that was recently returned on remand from the Oregon Supreme Court after the commission's denial of the application. I prepared some legal advice for the commission to review pertaining to the remand, and so that's the general purpose of the executive session this morning, after which the commission will be returning to open session.
Thank you, Mr. Radcliffe. Okay, so I will read a statement and then we will adjourn and reconvene at 10 or 9 a.m. The Oregon Water Resources Commission will now meet in executive session pursuant to ORS 192.660, Section 2, subsection F, which allows the commission to meet in executive session to consider information or records that are exempt by law from public inspection. Specifically, the commission will meet to discuss attorney-client privileged legal advice pertaining to the Supreme Court's remand of the commission's final order on East Valley Water District's application R-87871. Representatives of the news media and designated staff shall be allowed to attend the executive session. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. At the end of the executive session, we will return to the open session and welcome the audience back into the room. So now we will go ahead and adjourn for now, and we'll reconvene at 9 a.m.
And Vice Chair Smitherman, just before we do head into executive session, just one point of clarification. Commissioner Newman will be recusing herself, is my understanding, and so she will not be participating in the executive session.
Okay, understood. Thank
Correct.
you. You can go ahead and adjourn, and we will be back shortly upstairs. Okay, thank you, Mindy. So we are going to extend our executive session just for another 25 minutes or so, 25 minutes. We have some more things to discuss. So we will reconvene the public session at 9:25. Thank you. Convene the public session of the December 11th and 12th Oregon Water Resources Commission. And we're going to start off with agenda item A. I believe we have Elliot Crafton to speak with us today. Let's go ahead, Elliot, whenever you're ready.
Good morning, Vice Chair Smitherman, members of the commission. For the record, my name is Elliot Crafton, Water Rights Section Manager. I'll provide a brief summary of the topic. On August 7th, 2025, the Oregon Supreme Court issued an opinion in the matter of water right application R87871 in the name of East Valley Water District. The Supreme Court affirmed in part and reversed in part an earlier decision of the Court of Appeals, East Valley Water v. Water Resources Commission 328 OR App 790 2023, and reversed the final order issued by the Water Resources Commission denying East Valley Water District's application to store water. The Supreme Court remanded the case to the Water Resources Commission for further proceedings. East Valley's application is an application to store 12,000 acre-feet of water in a reservoir constructed on Drift Creek, a tributary to the Pudding River. The commission denied the application based on a determination that the public interest presumption under ORS 537.153 had been overcome. The commission reached this conclusion based on the public interest factor, ORS 537.170 sub 8 sub F, which requires consideration of all vested and inchoate rights to the waters of this state or to the use of the waters of this state and the means necessary to protect such rights. The commission found that the proposed appropriation impairs or conflicts with the beneficial purpose of Certificate 72591, an existing in-stream water right, and that there is no basis to conclude that the means to protect the rights are available in this instance. The court found that the commission correctly interpreted that the statutorily protected public interest in vested and inchoate water rights applied to both the quantity of water guaranteed to the senior water right holder and the beneficial use associated with those water rights, and that not protecting this public interest right may be a valid basis for denying an application. However, the court also held that, having determined the public interest presumption was overcome, the commission was obligated to consider all 7 public interest factors in ORS 537.170 sub 8 in evaluating whether the proposed appropriation would impair or be detrimental to the public interest. The court remanded the final order back to the commission to consider each of the public interest factors and issue a new final order on the application. Because this matter was remanded to the commission in the first instance, the department has not provided a recommendation on this agenda item. The commission has reviewed and discussed legal advice pertaining to the court's remand and may now have additional discussion or take action on this item. And with that summary, I'd like to provide Jesse an additional moment.
Thank you, Elliot, and members of the commission, vice chair. For the record, Jesse Ratcliffe with the Oregon Department of Justice. And so just to kind of orient both the commissioners and the folks in the room, we had an executive session that was for the purpose of the consideration of legal advice. And the point in the process that we're at now basically is for the commissioners to be able to discuss the consideration of the public interest factors, ORS 537-170 sub 8, and to address the Oregon Supreme Court's reference to the notion of the balancing of those various factors when it uses the term that the department or commission shall consider the factors to give direction to staff as to the decision that the commission is proposing to take, and then ultimately to provide guidance to the parties as to whatever their role in the process is, if there are to be exceptions filed to a proposed decision by the commission, for example. So I'm available to kind of help, as I was in the executive session, to kind of help move the discussion along. But ultimately, this lies with the commission as to its consideration of the factors and its direction to the department staff.
Okay, thank you both. Commissioners, any questions or comments, discussion? I know where shall we start? Joe, you want to kind of kick us off?
Sure. I think that given the Supreme Court's decision and the remand and what is asked of us, it seems to me that what we're being asked to do is show a little more of our work on the elements that the other public interest factors besides the one on which the commission's previous decision turned. And demonstrate that the commission has considered each of those elements, and as simple as that procedurally. And I think timing is of the essence in some ways, and so I would encourage us to attempt to move this in such a way that we could be in a position at our February meeting to make a decision, propose final order on this. That's how I seem to feel. I'm curious if others, especially those of you who weren't on the commission at the time, feel like that's a reasonable approach.
Yeah, thank you, Commissioner Mall. I think, there were only a couple of us who were on the commission at that time when that decision was originally made. And after reviewing and looking at what the Supreme Court is asking of us in the remand, it does appear that, as you said, Commissioner Mole, that we should be showing more of our work and articulate more of how we did look at the factors and how we considered all the factors, and show why, in particular, item F stood out and was a priority for focusing on, and why ultimately it was denied. I think that we should move forward with showing our work, looking at how we can rewrite some of this and articulate exactly our process and our method and how we came to that conclusion. And I agree that it would be good to hear some arguments, and maybe at the February meeting, that would be something that we could do if we have the time between now and then. So I am in agreement to try to move forward with drafting new proposed language to clarify and again, articulate what it was that we were trying to convey in the beginning, in the 2006, was it 2016? The original? Or 18, 19, sorry.
And commissioners, if I may, I know we announced this at the beginning of the before going into executive session and again in executive session, but since we've got a few more folks in the room, I just want for everyone's benefit, since Commissioner Newman is at the table, that she's recused on this matter and so hasn't participated in any deliberation. We're moving the microphone away. There we go. Hasn't participated in any deliberation or discussion on this and won't be or participating in the vote on this matter. So
Thank you. Appreciate that clarification. Any other commissioners have thoughts or comments? Commissioner Chiara?
Yeah, I'm like with Joe, I was on the commission when it was first heard, and I think we should go ahead with our showing our work as the Supreme Court has directed us to do. And I don't really have any other comment on that, and hope it can be dealt with, finally hopefully in our February meeting.
Thank you. Thank you, Commissioner Chiara. Any other commissioner comments? Commissioner Wolf? Nope. Okay.
So then, if I may, I think what I'm understanding from the commission is in the sense of showing work, and I just will kind of test this. So what we have in terms of the work that is already out there is we have the Water Resources Department's final order before it got to the commission, which contains a consideration of all 7 of the factors. The commission then took that one factor, the sub F factor, handled that differently, but didn't in its final order kind of return to the evaluation of the 7 factors. If I'm understanding what the commission is saying here correctly, it's one way to approach this to show the work would be to essentially adopt the department's consideration of the remaining 6 factors, readopt the commission's consideration of the sub F factor, and direct the department staff to prepare an order along those lines. So this, we'll be getting to a motion stage here because the commission will need to direct staff what to do. But because we've got a few elements to this, there's no need for the commission to make a motion or vote just yet. I'm just going to kind of toss out some kind of test assumptions based on what I'm hearing. If I'm not hearing objections to that initial concept, then I'll probably move to the balancing component of this. But since, if we end up in a position where the commission is providing direction to the staff in the form of a motion or vote, there's going to need to be a decent level of detail in that. And so that I can kind of keep everything organized and together, I'm going to be doing these kind of testing things along the way. That, of course, doesn't mean that the motion needs to look like that in the end, or that you vote a particular way, but it's just to kind of help keep us organized. So after saying all that, to reiterate it, one version of showing the work here would be to make it clear in an order that the commission is adopting the department's work, the department's consideration of the factors except for F, that the commission is readopting its own consideration of F. And that those would be elements of the proposed order that the staff will prepare and that would be sent to the parties. So if there are additional comments or questions, or you think I got it wrong, go ahead and jump in now on that.
I think that's straightforward, and speaking for myself, I think that's the direction that we should go.
Okay, thank you. So not hearing anything to the contrary on that, then the next piece that I'd like to move into is the balancing aspect of this. So the reason this is an issue is that East Valley Water District had made an argument in the proceedings below that said that the consideration of those public interest factors should essentially be a weighing, a balancing of the factors. The court didn't address that other than to say, we don't think we need to decide that issue now. And the parties can feel free to make their arguments with respect to balancing to the commission. The commission has options here. It can go ahead and direct the department staff to include its proposed position on that issue. It could choose to hear from the parties on that issue without including it in the proposed order. And then the other thing that kind of would need to be decided is the commission including the notion of balancing is sort of an alternative argument, maybe not the commission's preferred argument, but in the vein of showing its work, it's going to go ahead and balance, regardless of whether or not it thinks that balancing is required, or is there a decision that the commission thinks that balancing is required? So that's the sort of second subject that needs to be addressed in providing direction to the department staff.
Thank you. I do think it would be appropriate to hear from the parties. And I understand what you were saying about the balancing, and I did not take that as it was required to balance, but like you said, in showing our work, we're doing a piece of that by being more detailed on why it was we came to the decision that we did or are going to. And that is what you're talking about as far as balancing.
Yes, essentially that so if the commission were to decide, in the first instance, we think means consider. We've considered the factors. We're adopting the department's consideration except for sub F. We're adopting our consideration with respect to sub F. We're concluding based on that there's a detriment to the public interest. We've taken care of that. There's this balancing issue, and that we want to go ahead and address that. Basically, balancing may not be required, but in the interests of trying to, dispose of this issue, you could include a balance or not. If you do include a balance, it will need to, to actually do that, to say, we've thought about all 7 of these. Our particular interest in the senior water right, in the in the fact that it's a water right that's held in trust for the public. These are particularly weighty concerns. That would be the sort of direction that the commission could give to the department that then could be included in a proposed order if that's the commission's direction. So you kind of have an initial, if we think consider means consider, but we still want to to cover our bases and do balancing, that's kind of one decision. And then, what does that balance look like?
Mm.
Those will be the pieces of direction that kind of staff needs to turn this into a proposed order.
Thank you.
Vice Chair.
Commissioner Lee?
Yes, thank you. I just wanted to say that we look forward to hearing from both the plaintiff and respondent so that as we do our balancing and discuss this, we have their viewpoint to consider as well.
Thank you.
Yeah.
Commissioner Chiara?
I like the idea of saying that we don't really think that the balancing is required, but also putting it into a proposed final order to show that, yes, we did consider the other factors and kind of how we weighed them. I think that's one of the questions that was in the direction, question that I think, yes, we should do that. And definitely put in the caveat that we don't think we have to do this on every future application. This one merits having that looked at and, articulated.
Commissioner Mall?
Yeah, I wonder if any of the Supreme Court justices might be watching this because they're probably thinking, we did it, getting them to try and parse out the distinction between consideration and balance. I certainly feel like it's human nature when given a list of factors to consider that to weigh them against each other is a natural thing. I don't think it would be prudent for this commission to try to define what balance means, what a weighting system is, and this is the way it needs to be approached, because I think the context for this particular decision and any decision like these going forward will always have a pretty heavy context dependent piece of it. I think deliberation by its very nature demonstrates there's a consideration that it includes some sort of weighing of the different factors. And so as long as we can continue to do that with discretion without having to define this is what it means to weight these particular 7 factors, I'm all for that. I feel like that has been demonstrated. I don't know that it needs to be defined in as much as demonstrated. And I feel like we can consistently do that going forward. So as long as we can direct staff to come back to us with a draft proposed order in such a way that it demonstrates the consideration of those factors, I think we're good.
Thank you, Commissioner Mall. I agree with what you said about determining versus define.
Yeah.
I think that's clear. And that we don't need to go to that length in this process.
So thank you. I think that's enough for me to work with on coming up with some motion language here. So then the last piece of this, and I think I've heard a general sense of the commission, but again, testing this, that the work product here that you would be directing staff to prepare is a proposed order that would be signed by the vice chair, that would then be served on the parties, and that the parties would have an opportunity to file exceptions to, and the commission would then consider those exceptions. I think I'm also hearing a general preference for the idea that the commission would like to hear oral argument on the exceptions at the next commission meeting as well. So the proposed order and the way these things generally work is the proposed order says, here's the substance of what is being proposed to be done, and here's the next step in the process. So everyone understands the next step in the process. So the proposed order would also contain that language. You have the opportunity to do and file exceptions. You have the opportunity to present oral argument. Here's the deadline for those. A typical deadline for the filing of exceptions in administrative procedures is 30 days. then, you know, we would kind of look at the calendar and go from there and say, you know, for example, there's a commission meeting in February, that would, enable time for the filing of exceptions, the commission to consider those exceptions, oral argument to be presented at the February meeting, and then the commission would take that under advisement. It could either issue a decision at the February meeting, continue it to the next meeting, depending on the other agenda. So that is the sense I'm getting of process from folks. But again, if there's any discussion on that end of things, questions, let me know.
I think you covered it.
Okay,
Yeah.
okay. Then I am going to ask everyone to just bear with me here. So I am going to go ahead and draft a motion that anyone can choose to make or request modifications to here, but just to be of assistance on this, since it is going to be kind of a lengthy one, that shouldn't take me more than 5 minutes or so here, but.
Should we pause or can we hear from, we've got a couple people signed up for public comment. Do we wait on that until after a motion is given?
Yeah, so that's a good point. Well, without
We have two.
turn my mic off. So if we have commenters on this item, the commission has some options here. My recommendation is going to be to kind of stick to an established process. So the typical process here would be, the kind of issuance of a proposed order, which is the direction we're heading, the opportunity for the parties to be able to see in writing what the commission is proposing to do and to make their argument at that point. To kind of stay within a fairly recognizable process here, my advice would be that we try to kind of treat everyone equally and do things in that kind of formal form rather than taking public comment on this without any kind of set boundaries. That said,
comment would not be
that we can talk, if the commission wants to hear from folks today, we can talk about that. I think we just probably want some discussion around the parameters of what that looks like. This isn't like a typical kind of public comment process. We are still kind of operating under the Administrative Procedures Act here.
Okay.
And so there are some sideboards that go along with that.
So what I'm hearing is that we should not hear public comment from the two that have signed up today and ask that they come to the next meeting or at a different time to present their comments.
My advice is that's the lower risk option here, is that we very clearly spell out for the parties what their procedural opportunity is, to file written exceptions with a specific deadline. And then the oral arguments presented at the next meeting, so that the parties absolutely will have an opportunity to present to the commission on this. We're not depriving anyone of that ability. It's just doing it at a time and place that is a little bit more structured. If the commission still wants to entertain public comment today, then my recommendation would be that we talk a little bit about what that looks like. So that we again try to kind of keep some sideboards on it.
I have a suggestion. if I
Yes,
may.
go ahead, Commissioner Arnold.
How about we give you the time you need to create the draft motion, we deliberate, make that motion. Once that motion is made and we have a pathway, then clearly we have two people who want to comment on this today. I'd like to give them the opportunity to do so, but not in a way that, from a process standpoint, precedes our decision in the direction we're giving to staff. Does that attenuate the risk to some degree?
Yeah, I think my suggestion would be that we just Yeah, maybe we ought to have a quick recess on that so I can think about that one. Yeah. And in the meantime, I'll also be working on the motion language. Yeah.
Okay,
Okay.
all
Okay,
right.
Great.
Thank you, everyone, for your patience while we figure this out, and we'll take a quick 5-minute break.
Yeah, if
All right, thank you, everyone, for your patience. We're going to get back to our conversation on agenda item A. There's been discussion on a motion. And I think, do we have a motion from any commissioners? Go ahead, Commissioner Mall.
I have a motion to make, Chair. I move that the commission direct the Water Resources Department to prepare a proposed order on remand with the following 5 elements. Number 1, a consideration of each of the ORS 537.170 subsection 8 public interest factors, which adopts the consideration of the public interest factors in the department's final order, with the exception of ORS 537.170 8F factor. 2, an adoption of the Commission's consideration of the ORS 537.170 subsection 8F factor from the Commission's final order. 3, a conclusion that the application will impair or be detrimental to the public interest and is denied based on the consideration of the ORS 537.170 8F factor. 4, a conclusion that the consideration of the public interest does not require balancing of the public interest factors, but that in the alternative, the Commission balances the factors and concludes that the balance requires denial of the application because it will impair or be detrimental to the public interest. Specifically, while the other public interest factors do not weigh against the public interest, the weight of ORS 537.170 8F factor is sufficient to require denial because of frustration of the purpose of a senior water right held in trust for the people of Oregon. And 5, an opportunity for the parties to provide written exceptions on the proposed order with a 30-day deadline, and an opportunity for the parties to present oral argument to the Commission on the exceptions at a future Commission meeting.
All right, do we have a second?
I second the motion.
Okay. Commissioner Lee? Commissioner Wolf?
Yes.
Commissioner Mall?
Yes.
Commissioner Kier?
Yes.
And I vote yes. Motion passes. The next item was, we have a couple people signed up for public comment, and we want to be clear about the process if we do allow public comment at this time. Mr. Ratcliffe, could you provide us with, if we did allow public comment today, what that process looks like and what the parameters are?
Sure. Thank you, Vice Chair. So for the record, Jesse Ratcliffe. So my understanding based on conversation on the break is that the folks signed up for public comment are the representatives of East Valley Water District and Water Watch. So we have the two parties here, which is one of the things that I want to make sure is that since we are in this kind of posture that we have both parties present, that we have equal time for them to present. I guess I would say, the primary vehicle for them to be able to make argument is going to be through the exceptions, both written and oral, to the proposed order. With that, if the commission does desire to hear from them today, I think it would be appropriate to keep the comments fairly brief, with that kind of understanding. So that's what I'd recommend in terms of kind of sideboard, so that we're ensuring basically due process here, that we have, we're giving parties the equal opportunity, and we're being clear about what their primary opportunity is for presenting argument here.
Okay, so I just want to ask the rest of our commissioners, are you agreeable with that if we were to hold comments to 2 to 3 minutes max? And whether you are agreeable, I don't think we need an official vote on that.
I would just recommend that we make it 3 minutes,
Okay.
period.
Okay, the proposal here is that we allow commenters to present to us for 3 minutes. Is there anybody opposed to that? Any commissioners opposed to that? Okay, it appears that no one is opposed, so we will allow each the commenters to come up and talk with us and limit it to 3 minutes. And we'll start with Brian Posowitz. Sorry if I didn't pronounce that correctly, from Water Watch. And just a reminder that official arguments will be presented at a later date.
Morning, Vice Chair Smith and members of the commission. My name is Brian Posowitz. I am. Do you want me to start over? Good morning, Vice Chair Smitherman, members of the commission. My name is Brian Posowitz. I am a staff attorney at Water Watch of Oregon. I've been representing Water Watch more or less throughout this case with the help of an outside private attorney to help us with the appeals process. I signed up to give public comments today, not knowing how this was all going to go or where you were all going to land. I want to say, first of all, we support the denial of the application for reasons that have been thoroughly expressed in the contested case and in the exceptions we filed back in 2019. Very much appreciate your thoughtful discussion today about what the Supreme Court had to say and how to address the concerns that the Supreme Court raised. And I think we're fine with the process you've outlined and the motion that you've adopted today. And with that, I think I'll save whatever else we may have to say for the formal process that you've outlined. Thank you.
Great. Thank you. And thank you for being here today to speak with us.
Sure.
Next up, we do have Kirk Mag. Did I pronounce that correctly? Mog. I'm so sorry. I should have known.
Vice Chair Smitherman, Commissioners. For the record, I'm Kirk Mogg, an attorney from Stoll Reeves representing East Valley Water District, and I've been representing East Valley Water District throughout this process. This matter involves an application for a new water storage permit. It's the culmination of a multi-generational effort by a group of farmers seeking a sustainable and reliable source of water. And it's a result of years of collaboration between East Valley farmers, the Water Resources Department. It also involves a significant investment of both private and public dollars in the proposed project. I appreciate the Commission's decision today to allow a proposed order to be presented for consideration, for briefing to be filed, and for oral argument to be presented. This is an important matter, an important case, and given the investments of time and resources and the importance to the applicant here, I think it's critical for the Commission to be able to give the consideration that's due. East Valley believes that a correct application of law would require a new final order approving the application based in large part on findings from the administrative law judge and the director, the bulk of those findings have previously been adopted by the Commission. As I've mentioned, given the decades that have been involved here, the hundreds of thousands of dollars invested by both East Valley Water District farmers in the state of Oregon, this matter deserves each of your careful consideration. Some comments this morning suggest that denying the application may be a foregone conclusion and that the Commission just needs to show its work. But I would encourage each of you to carefully consider the public interest factors for the purpose of deciding whether the proposed use of water is in the public interest. There's been some discussion this morning about the difference between considering and balancing, and as some of you have noted, in many cases, these may be one and the same. What's required by statute is a consideration of the public interest factors, but to interpret consider, it's necessary to identify what is the purpose of that consideration. Here, the purpose is to determine whether a proposed use of water is in the public interest, a single public interest based on a consideration of 7 factors. This necessarily requires that each of the 7 factors be considered in relation to one another. to determine whether or not the proposed use of water is in the public interest, the public interest. East Valley Water District welcomes the opportunity to further brief and argue this issue and appreciates your time and careful consideration of this matter that is of the utmost importance to a group of Willamette Valley farmers and to irrigated agriculture across the state of Oregon. Thank you.
Thank you. Right on time. Right. Appreciate the comments, and thank you for being here in person to speak with us. I think that concludes agenda item A. And we can move on to agenda item I. We are mixing it up a little bit, so if you refer to your revised agenda, we are going to be discussing Oregon's Integrated Water Resources Strategy Work Plan Development. And thank you, Elliot, for your presentation as well.
Great. Vice Chair Smitherman, members of the commission. For the record, my name is Crystal Grinnell. I'm the Integrated Water Resources Strategy Specialist with the department, and we're here today to discuss our first biennial work plan. Last time we met, we were discussing the adoption of the 2025 Integrated Water Resources Strategy. So the next step in the process then now is to create a biennial work plan. So I'll go through what we're currently working on here. So in the agenda today, we just have a brief discussion here today. The first half we'll discuss draft one, how that was really developed and some background on that. So draft one is very much that. It is a draft version of a work plan. We're still working on it. It is an interagency work plan. So you should have all received that with your materials. And then I will just make a few comments about our proposed next work plan that we're going to be starting to work on soon. So the development of the 25-27 work plan included a input from about 14 different agencies, so including Water Resources were the 14th there. So a lot of the agencies that helped participate in the update of the Integrated Water Resources Strategy, but really just the focus here is trying to get all of the things that we're doing written down in one location. So the way that we've approached this work plan is to split it into two parts. So something that you'll recall that's something that's new for the 2025 Integrated Water Resources Strategy was identifying priorities. So in that version, in the 2025 document, Appendix E is where you can find those outlined. So those priorities are not completely across all agencies. It was really primarily developed by about 6 agencies with some additions. So those priorities, we really want to track those, but we didn't want to exclusively just be looking at those. We wanted to also make sure that we were considering the rest of the full IWRS. So part 2 of the work plan is where you can find the other actions that agencies are taking, and that's where the fuller picture of closer to 14 agencies are representing their work. Just by nature of having priorities versus integrated water resources strategy actions, some of the stuff in part 2 is a little bit more related to ongoing work and less related to those priorities. And we're trying not to duplicate information across the 2 parts as well. So just for a graphic for folks to cue into what I mean by priorities when I say that. This is a table that collapses all of them onto one location. You're not seeing the agencies that have been assigned to each of the priorities here. But generally, this is what we're looking at when we say the IWS priorities. We're talking about the 15 tasks that are related to the 3 priority areas that were developed by agency leadership. And then when we say the full IWS, so part 2 of this work plan, we're really focusing on the full IWS, the framework here where we're thinking about the full IWS in terms of the 4 objectives and 48 actions. So just a few comments on the direction that agencies were given in terms of contributing to the work plan. We really wanted to keep this very high level. A lot of agencies have a lot of requirements upon them regarding tracking things. So we really want to make sure that this work plan approach is, inviting many agencies to participate and keeping them at the table. We want to keep things high level and simple. And we also want to minimize the tracking and reporting effort that we have on this. We are not required to do a progress report for the integrated water resources strategy. However, we think that there is a natural reason to do that if we are doing a work plan. We want to be able to show at the end of that biennium what we've accomplished. So we do plan on showing a progress report to show what we've accomplished. And we're also going to be leaning on other more detailed work plans. Instead of trying to keep that detail in here, we're going to let agencies just direct us to their other more detailed work plans. That's certainly the case for the Water Resources Department. We have more specific information elsewhere. We want to just keep it very accessible to folks so you can see what is being done on the integrated water resources strategy at a high level over the next year and a half, essentially. I do want to make a note that we had, while we were working on this process, we did send out a letter to the tribes in October, and the purpose of that letter was to let them know that we're undertaking this new work plan process. We had several tribes submit comments on the integrated water resources strategy on that final draft, so we wanted to make sure we were keeping them informed about next steps. And that letter said that we were going quickly to work on developing our 25-27 work plan, and that we would also be beginning our 27-29 work plan development in 2026. So we wanted to make them aware of those 2 processes. The Burns Paiute tribe reached back out to us and requested consultation. So we did meet with them before this meeting, and primarily we discussed steps for co-management. So that was primarily what we heard from them. We haven't received any other comments from other tribes to the state. So next steps on the 25-27 work plan. Again, the version that was included in your commission materials is just a draft. Right now, we are working with the 13 other agencies to finalize that draft, and with that goal of finishing that by the end of the month. So that would be done by the end of the year, so we can shift our focus to the next work plan. So here's just a simple diagram showing what we plan to do loosely over the next year and a half while this biennium is playing out. So in 2026, we plan to have some agency check-ins, and that would be just, at some frequency we have not determined yet, but then that would push us to the end of the biennium, which is middle of 2027. Sorry, and then that's when we would just take a look at what we've accomplished, give us some time to prepare a progress report. So we anticipate being able to publish a progress report in the fall of 2027 to show what we've accomplished. So now moving on to the next work plan that we have planned here. So this diagram here, I'll just walk through it quickly. The idea here is that in an ideal world, this 25-27 work plan that I just talked through was created quickly because of the timing of when we adopted the integrated water resources strategy. It was adopted after our biennium officially began. And so we wanted to quickly create that so it could reflect what we knew our budget included. So the plan moving forward, we would really like to have our work plan development align with our budget processes a little more closely. So this diagram shows our typical cycle where in an even year, we start looking at legislative concept and agency budget development. that's a good time for us to start talking with other agencies and develop an integrated water resources strategy work plan. All of that information would then be nested into the governor's recommended budget if it was, if it makes sense. And then at that point, it's out of our hands, really. We have the long session needs to play out. And then the legislatively adopted budget isn't done until usually the end of June of a legislative session. And so at that point, we would see where did our budget land and what can we actually accomplish. And so that's when we would begin the clock on implementing our work plan, once that official biennium begins. So that's what we're hoping at this point would be kind of the cycle that we're on, where we're really being proactive and getting in front of the legislative concept and budget development component to discuss that collaboration that really needs to happen to be able to integrate or to implement the integrated water resources strategy. And then the last slide I have to share with the commission is just noting that we do have a lot of question marks out there for the 27-29 work plan development based on an executive order that just was released in October. This executive order really focuses on climate resilience, and there's a lot of overlap with the integrated water resources strategy. And in the executive order does call out some very specific things that overlap with our integrated water resources strategy process as well. So we're still waiting to learn more from the governor's office on this, on how we're going to integrate these things. So all I can say there is look forward to hearing more as the year goes on with that. And I do believe that the commission will be briefed in February from the governor's office more on this executive order. So more to come on that. Right, any questions?
Thank you, Crystal. Commissioners, questions or comments? Commissioner Lee?
I was noticing as I looked through 25, 27, that a number of the programs that are listed were actually also listed as program cuts to the Senate to the Joint Ways and Means Natural Resources Committee. So in this draft, are you updated or are you going to reconcile what will happen with those in February?
Are these programs, WRD programs, or other agencies? Oh, yes. Okay, yeah, thank you for that question. So the way that we're approaching the finalization of the work plan, we're letting agencies enter their own information. So they should be entering things of essentially with the information, the knowledge they have on their budgets. We also have, so internally we're discussing, we've got work plans that are developed and we're looking at basically reflecting this IWS work plan will reflect our WRD work plan. So there will be, of course, shifts that happen later on in the year, but we're trying to get things written down that we think that we're going to accomplish. We do, just in terms of the IT component, there's still things that we're going to be able to do, maybe not everything we wanted to do originally with an original budget. So flexibility is going to be the name of the game as we go along with this work plan and just knowing what we can actually accomplish.
Yeah, good work under the financial conditions we have to deal with right now.
Yes. Yeah, thank you.
Commissioner Mall?
A comment, I wanted to laud Ivan, you and all of the staff for investing in the recent two-day Willamette conference in Corvallis and supporting not only that financially, but also with Raquel's presence and Alyssa Meckin's coordination there. I think that we're seeing outside of the fixed plans just a lot more integrated sort of thinking across agencies, and that was alive and well in Corvallis and really exciting, despite the difficult state and federal situation that we're under when it comes to natural resources. So I just want to encourage more of that as much as possible to give the staff and the programs the latitude to take opportunities, even if they don't necessarily fit in one of the prepared boxes, because I think the benefits of that are already evident just in the amount of energy you're seeing and staff and partners across the natural resource agencies. So bravo, and keep that up and let us know how as a commission we can continue to support that.
Great, thank you.
Thank you, Commissioner Mall. Commissioner Newman?
Yeah, good work. I mean, I think it's really helpful to have this chart to kind of see the specifics. And I appreciate the fact that most of the items are listed with not banned any longer.
Not anymore.
Okay. Good work. I appreciate the matrix that sets out the specifics regarding the priorities. And I appreciate the fact that most of the entries use active words. You know, sometimes there's a little bit of, well, review, or I mean, something that isn't as strong. So I just want to kind of keep that in front of mind, that particularly for all the priority areas, it should be active verbs. And then the other thing I noticed, there is some comment from time to time about coordination with other agencies. I think maybe there could be even more of that in some of these specifics, and I know you're trying to keep them kind of high level and not too complicated. But just something to think about in the next draft. And also, if there are places where you could mention specific coordination with tribes. I mean, I noticed that there's USGS is mentioned, SWCDs. So it's not just other state agencies, which obviously are the ones that we have control over.
Right.
But anyway, those are just two thoughts of trying to sprinkle those things throughout as appropriate, if possible.
Okay, great, thank you.
Thank you. Any other comments? I just have one. Well, first of all, you've done a lot of work. Again, back to Commissioner Mall's point. I really appreciate all of the interconnections between all the state agencies, and looking forward to our February meeting, where we're going to be having a joint meeting with Department State Lands or Land Conservation, Department of Land Conservation and Development, which is really important. And so looking forward to having that collaboration and conversations with them at our next meeting. I have a question on priority 1.2, and I don't know if you probably don't have it in front of you, but it says none this biennium.
Yes, we actually do have a revision to that.
Okay.
In the current draft that we're working on. We do have something we're doing.
Oh,
on that.
okay.
Yeah.
Well, I'm curious about the language in the actual task. Provide guidance for what constitutes reasonable use of water. How's that different from beneficial use of water?
I think it's intended to be broader.
Okay.
Again, I didn't create the language.
Yeah, no, it's okay.
But
I don't want to
yeah.
put you on the spot. If
Yeah,
you have-
the piece of information I can share on that is I feel like it was intended to be broader and include other agencies too. So I think Department of Agriculture's input on that, maybe the wording was reflected
Okay.
in that regard. So I'm sorry I don't have more.
No, that's
detail
okay.
on
It was just,
but
I was
yeah.
more curious if there was, and that I understand if it's more general and it's incorporating all the other agencies and not specifically
Just
what's written in law on beneficial use. So thank you for that. Any other? Commissioner Mull? Yeah. Yes.
Brief clarifying question. You said that the governor's office, there would be a briefing from the governor. You'd be a briefing about the resilience request associated with the governor's office. Will that be by a representative of the governor's office, or could we request that?
I
at the
believe it
meeting
will
itself?
be, but the
The governor's office will be providing a briefing on Executive Order 2526 in February to the Joint Commission meeting.
Great.
I'll have more information for you during the director's report tomorrow.
Wonderful. Thank you.
I think that's all our questions for you, Crystal. Thank you so much for your work and the whole team behind you on this. We do have one signed up for public comment. April Snell.
Good morning.
April Snell, thank you, Director for the water resources comment. I want to make a couple comments on the integrated water resources strategy work plan session. In being consistent with comments that I made previously, I do want to, again, note that this is the first IWRS update that was developed without any broad stakeholder input. And at the commission meeting where this was adopted, you may recall that I made comments that indicated I understood that we needed to move forward with the update of the existing IWRS, but really encourage the commission and the department to, one, ensure that there is input from stakeholders for the next update, and that the work plan also have stakeholder input to help not only inform the work plan to make it better, but also with the recognition that many of us can be helpful in magnifying the priorities of the IWRS work plan. Wow, that got really loud. And then also looking at the resource constrained environment that we're in. Speaking for myself, I am a lobbyist. We do care very much about making sure that water is funded adequately. That's going to be really important this next session and beyond, as agencies, including this one, are asked to make difficult choices. And so I again ask the commission and the department to look at how you can involve stakeholders in the development of the work plan and also in its future iterations, in-stream and out-of-stream, agriculture, municipal, tribal, all the folks that have been previously involved and engaged should have an opportunity to help make it better. And that's not to say that what the agencies are working on isn't good, but particularly if we want to have resilient communities, that's the Oregon way. We get input from the communities and not just at the end of it. Involve us each and every step. And I think it's great that the agencies are talking, but when I look at the work plan, it seems very much an ivory tower insulated agency process, and we can be helpful. And that's just something I want to make sure that we're indicating, and really do appreciate the efforts of staff to put this together. And there's a lot of work to be done. And so I think it will be more successful if you involve more hands and more voices. So I'll also say lastly that it is helpful to the extent that it's possible to have some of these discussions outside of the legislative session. And with 2026 being the short session, that's a better than doing it during 2027 to have stakeholder involvement. And again, recognizing that there will be discussions about the current budget as well as the development for the 2027 budget in the not too distant future. So thank you very much for your time. Happy to answer any questions.
Question. My turn. Any questions for April? Commissioners? I recognize that. Thank you. And I just want to say thank you for your comments, and absolutely stakeholders are very important in this process, and we're on the ground doing the work. So appreciate those comments from you, April. Thank you. All right, we do have another person signed up, and I'm sorry I missed that earlier. It's Harmony Burright. Come on down.
Make sure your microphone is turned on. The red light at the bottom.
This one?
Yeah.
Looks like it's on. We'll do a mic check. Does that work?
Yes,
Okay.
we hear you. Thank you.
Good morning, Chair Smitherman, members of the commission. My name is Harmony Burright, and I am here as the Chief of Staff of the Water Caucus today. The Water Caucus is a group of bipartisan, bicameral legislators and staff working on water security for Oregon. And at present, we have 30 members, both Democrat, Republican, House, and Senate. And I'm here today to kind of
chat with you a little bit about the priorities of the caucus. Really appreciate all the work that's gone into this work plan and just all of the work that Crystal is doing to bring agencies together. It's a monumental task, as you know, having all of these various natural resource agencies with different responsibilities associated with water. We probably need 3 crystals at least. I don't know how many crystals we would need according to Crystal, but being in a part-time capacity for the legislature, trying to work across agencies, I can just kind of affirm how challenging it is. And really bringing forward kind of the opportunities around partnership and alignment on priorities. Working with legislators, they're hearing from communities, they're hearing from agencies, they're also hearing from stakeholders and partners. And to the extent we are able to kind of align what they are hearing from those various groups, that's where we have the greatest ability to kind of move forward with policies and investments on water. As you know, the natural resource agencies share a very small fraction of the overall general fund. And so when we talk about advocating for water in Oregon, we are all going to be more effective if we're kind of working together collectively to advocate for that. And also showing truly how it is integrated with all of the, well, not all, but many of the priorities of the legislature. It's relevant to wildfire, it's relevant to housing, it's relevant to so many issues that legislators care about. And maybe at times we need to be talking about water in relation to those concepts, not necessarily as a natural resource issue. Even though it is a natural resource, it kind of underlies everything. Without water, we don't, have a functioning economy. We don't have communities. So I just wanted to chat with you a little bit today in hopes that we can, we're working with the governor's office and others to try to kind of continue forward with achieving alignment between our respective priority areas. But I did send along to you Water Caucus priorities. It's just a 1-pager, pretty high level. Was glad to see that there are many things in the interagency work plan that are kind of aligning with some of this work, specifically around the 3 areas that are in my portfolio to do interim work are water data, water planning, and water infrastructure funding. In terms of, how we move forward with those, I just want to kind of highlight to you that in my work with legislators, a lot of them, because they are not in the water world, that's not where they come from. There's a real opportunity around the integrated water resources strategy for some level setting, just with new legislators, and then also continuity over time. So where there is shared interest, it's really about making sure that we're continuing to tell a consistent and cohesive story, because legislators don't know oftentimes what happened before they arrived. So the work that Crystal has done to kind of track and report on progress and showing how all of this is additive, that we're kind of building on the strategy over time, is very effective. In terms of bringing forward more specific goals for the caucus to consider, we're talking about things like how do we just maintain a baseline for water data, for instance, if we're interested in building long-term records with knowledge that defunding data prevents us from building those long-term records. How do we just set a baseline for maintaining and then in good years increasing investments in water data? These priorities were formed primarily through extensive research on documentation, including the integrated water resource strategy and one-on-one conversations with all legislative members. And I will say that by and large, the legislative members are primarily interested in issues that affect their community, and water infrastructure funding kind of being the big one. But it's such a big topic. There's so much that can fall under the banner of water infrastructure, water reuse, water conservation. And so again, like thinking about how can we frame or reframe this in a way that's going to be compelling to the legislature. And so really this is just to, make you aware of the priorities we're working on, hope for continued conversation and coordination so that in future, in future sessions, as April said, we can have the department, communities, and stakeholders and partners kind of in alignment. I think that's what the IWRS really could allow for, is that alignment. So when you do go to the legislature, they are hearing a similar story and really see very clearly those areas of investment. Because a fractured narrative on water is what will ultimately make it most difficult for the legislature to meaningfully advance policies and investments. So I'm happy to take any questions and also happy to bring co-chairs before you at any time to have a conversation. But yeah, just kind of getting started on formal interim work.
Thank you, Harmony. Appreciate your comments. Do we have any comments or questions from commissioners? Commissioner Lee?
Yes, I really appreciate all the work the caucus is doing and the momentum you have in growing the number of members in the caucus, and especially with the House Water and Agriculture Committee extending additional funding to the department over the past couple of years. It was really needed. So thank you for all that work.
Yeah, the caucus came together in the 23 session around the bipartisan drought resilience and water security package, which, was probably one of the more significant sources of funding for the department, and excited to continue to track that work and see what integrated outcomes result from that work.
Excellent. Thank you. Commissioner Newman?
I hate to give Crystal more work, but I'm just thinking that maybe an overlay, or looking at the IWS work plans and maybe mentioning some of the legislative priorities in appropriate places there, or just little, stars or color coding or something that says, hey, this is something that the Water Caucus really cares about, just to make that further link. I think would be useful.
Yeah, and I think there's also more work that the caucus can do to kind of, now that the IWRS is adopted and we're seeing the work plan, I think there's some effort on, in both of our roles to kind of help marry the language and the concepts to the extent there is alignment.
Right. And you're right. You guys can look at the work plan and say, hey, that, we really like that particular one because it relates to our priorities too.
Yeah, and when someone becomes a member of the caucus, I am giving them a copy of the Integrated Water Resources Strategy to read, and that really helps, again, set that baseline for understanding. The physical copies are very helpful. One legislator told me that they brought it on vacation with them and read it by the pool, which I thought was, I know, it made my heart sing a little bit. I was like, also, you're crazy, but it's very, they really do care. They really are, I think, hungry for information, but packaging that information in, bite-sized chunks for legislators is also something I'm working on and struggling with because the they are just, they have to become conversant in so many issues, but also involving, stakeholders and partners, because if they're hearing a fractured narrative on water, what I see with legislators, they're just like, I don't have capacity to really engage on this if I'm not hearing a cohesive and coherent story. So to the extent we can achieve alignment, and it doesn't have to be on everything. I think there are those areas where people are like, yes, we all agree on this. Okay, even that for water is hard to get funded. So let's focus on those things that bring us together. Where there's disagreement, that is okay. The legislators are going to hear the disagreement. Where we can just be kind of transparent about where that exists, I think that's really helpful too. And that's part of my work, is bringing forward nonpartisan kind of just here's what everyone is saying, so that people can at least attempt to break out of partisan narrative on water issues. It's tough to break out of, out of that, that binary on things, but every legislator from our conversation walks away with at least one little new tidbit of knowledge or curiosity, or maybe a new person to talk to. So
Any more comments, questions for Harmony? Thank you so much, Harmony. Appreciate your time and coming to speak with us today. Thank you for your comments. Okay, so on the agenda, it says we have a 15-minute break. However, I was thinking maybe we could keep that to a 5-minute break so we can get caught back up with our agenda. So 5-minute recess and then we'll be back. Great, thank you. We are back in session. We're going to take up agenda item G, water project grants and loans and irrigation modernization funding recommendations and program updates.
Good morning, Vice Chair Smitherman, members of the commission. For the record, my name is Louisa Mariki, grants analyst, and I'm joined by Adair Muth and Maggie Smith. We are here to present the funding recommendations.
It's your mic
A
on?
little bit.
That good?
Bring it.
To present the funding recommendations for water project grants and loans and irrigation modernization and program updates. This effort is supported by recommended action 13C of the Oregon's Integrated Water Resources Strategy. And this is to support planning, feasibility studies, and project implementation. At OWRD, this work is done within the Planning, Collaboration, and Investments Division, or PCI for short. And within PCI, we utilize various tools to build partnerships and incentivize communities to pursue integrated and innovative solutions to complex water challenges and uncertain water future, including strategic investments. Within the Water Resources Department, we have about 7 funding opportunities. Several are structured to help communities define water-related challenges, identify opportunities, assess feasibility, and then pursue funding for implementation. Water project grants and loans and irrigation modernization funding is designed to help support implementation. This map showcases all funded projects from 2016 through 2024. Colors indicate the different funding opportunities. As you can see, we funded projects across the state. Today, we are here to present the funding recommendations for water project grants and loans and irrigation modernization funding. Water project grants and loans supports projects that address in-stream and out-of-stream needs and achieve public benefits in 3 categories: economic, environmental, and social cultural. Irrigation modernization funding supports water supply projects that enhance irrigation efficiency on existing agricultural lands while delivering the 3 public benefits: economic, environmental, and social cultural. During the 2023 session, the Oregon legislature approved $50 million in one-time funding for irrigation modernization projects. The intent was to provide state match funds to help Oregon access federal funds that were available for irrigation modernization. For efficiency and to get dollars out the door quickly, the department is using the structure of the existing water project grants and loans program with some minor adjustments. Some key differences between water project grants and loans and irrigation modernization funding includes, for water project grants and loans, there is a 25% match requirement of the grant request amount, and this can be in kind or in cash. For irrigation modernization funding, there is a very specific federal match required in order to be eligible. And this is the Natural Resources Conservation Service funds associated with an authorized watershed plan, U.S. Bureau of Reclamation Water Smart Grant, or the U.S. Environmental Protection Agency's grants that are eligible to be on the Department of Environmental Quality's intended use plan. For irrigation modernization funding, there's an additional statutory priority given, and that is given to projects that legally protect a portion of conserved water, that legally protects a portion of conserved water and stream commensurate with the amount required by the Department Allocation of Conserved Water Program. Aside from these key differences, nearly all other elements are the same. Next, I'm going to highlight changes enacted through House Bill 3364 during the 2024 legislative session. The public comment period on applications has been shortened from 60 to 30 days. Entities required to have a water management conservation plan must have their plans submitted by the application deadline. Plans must be approved by the funding decision date rather than the application deadline. The technical review team now must submit its recommendations to the department, which considers both the TRT's recommendation and public comments before making a funding recommendation to the commission. Previously, the TRT's recommendation went directly to the commission. Long-term seasonally varying flow compliance monitoring is now an eligible expense covered by grant funds. The bill clarifies that seasonally varying flows conditions may be applied directly to the underlying water right, not solely to the aquifer storage and recovery or recharge permits. And finally, the bill established a reporting requirement to the legislature and the commission every 8 years on funding programs. The department will need to do rulemaking and align new rules with statutes. The timeline for this is to be determined. Moving into this second 2025 funding opportunity. The department runs the water project grants and loans and irrigation modernization funding cycles concurrently for efficiency. We run 2 funding cycles per year dependent on the availability of funds. Currently, there is $607,529 and about $3.8 million available for provisional award with lottery bond proceeds from a May 2026 sale for water project grants and loans. And there's roughly about $4.3 million available for irrigation modernization funding. Since the September Commission meeting, one funding update has occurred pertaining to unobligated funds. The department received a request from the North Unit Irrigation District requesting additional funds for their Bend Headworks Fish Screen Replacement Project, which was awarded $1,971,924 by the commission in December 2024. Department staff evaluated the request, and in accordance with the delegation of authority granted by the commission at the meeting in December 2024, the department approved a one-time increase of $197,192, which is a 10% increase of the initial grant award. North Unit Irrigation District has been provisionally awarded funds from the anticipated May 2026 bond sale, leaving the available funds to award for water project grants and loans from that bond sale at that roughly $3.8 million that I just mentioned. This is a brief overview of the application review process. When we receive an application, OWRD receives the applications for eligibility and completeness. The applications that are found to be eligible and complete are posted online for a 60-day public comment period and sent to affected tribes, inviting an opportunity for government-to-government consultation and feedback from the tribes. After the comment and review period, the multi-agency technical review team evaluates the applications and meets to discuss them, reaching a funding recommendation. We will talk about that review in a moment. The funding recommendations are then posted online for a second public comment period, and we reach out to tribes again. We then come to you all with those funding recommendations and any public comments received from tribes. Then you get to make the final decision on the funding awards. Applications for the second cycle were due on July 16th. We received 6 water project grants and loans application requesting about $2.9 million and 3 irrigation modernization applications requesting about $7 million. As a reminder, we have about 4.4 in total million dollars for water project grants and loans and about $4.3 million available for irrigation modernization. We posted the 9 complete applications online for that 60-day public comment period from July 31st through September 28th. We also reached out to tribes for comments at this time. We did not receive any comments from tribes. We did receive 5 public comments in support of the Big Butte Creek Water Acquisition and Irrigation Efficiency Project, 2 comments in support of the Oxbow Ranch Irrigation Modernization Project, and 2 comments that raised concerns with the Falcon Cove Beach South Spring Intake Project. The technical review team is composed of the 7 agencies on the left-hand side of the slide. Representatives from these agencies evaluate the applications and consult with the internal experts, with their internal experts, to assess the public benefits. When the TRT scores the benefits, they consider both the positive and negative impacts of the project. They consider the likelihood of achieving the claimed benefits, the changes on the ground that will result from the project, and they also consider the supporting evidence or documentation to ensure that the public dollars will result in the claimed benefits. This slide is an overview of the scoring for water project grants and loans. There are 3 public benefit categories that I mentioned: that economic, environmental, and social cultural. Each category has 6 questions in total. The maximum score that can be achieved per question is 10, which means there's 60 points that somebody could score per category. The next row is the potential preference points for water project grants and loans and irrigation modernization, and that's a total of 20 points. An application for water project grants and loans can receive a total of 200 points. The scoring for irrigation modernization funding is essentially the same. There is, however, 10 additional points for legally protecting stream flow, commensurate with the amount required in the allocation of conserved water statute. For irrigation modernization projects, the total that they can receive per project is 220 points. As we discussed in previous meetings, it's not expected that projects will score 200 points in total for water project grants and loans, or the 220 for irrigation modernization, because that would mean that they have scored exceptional benefits for all of the 18 questions being asked in their application. Having said that, it's important that we ensure that all funding projects achieve public benefits in the 3 categories. The department set a minimum score of 5 out of 60 in each category. And this signals that public benefits are more than minor, and each category must meet that minimum score. With that said, I'm going to pass it over to Adair, who will tell you more about the funding recommendations for this cycle.
Thank you, Louisa. Is this working? Okay, perfect. Good morning, Vice Chair Smitherman and members of the commission. For the record, my name is Adair Muth. And as Louisa mentioned, the TRT members met to discuss, score, and rank project applications. They ranked the projects based on the greatest public benefit score, and then made their funding recommendation on 2 things: on that public benefit score and the available funding. So based on these items, the TRT recommends funding projects ranked 1 through 4 for water project grants and loans, and projects 1 and 3 for irrigation modernization. So all 3 irrigation modernization projects met the minimum public benefit scores required to be recommended for funding. However, there's insufficient funding available to fund all of these projects with the total request of over 7.1 million. So the TRT discussed several options, including only recommending the project ranked number 2, which requested about 4.2 million, but felt strongly that the top ranked project should be funded. They also found that project ranked number 3 provided sufficient public benefits to warrant funding, and therefore their recommendation was funding projects 1 and 3. These are the 4 water project grants and loans projects recommended for funding by the TRT. This slide includes the project rank, the project name, and the funding requested. This is a total of just under $2.4 million. The top ranked project, the Oxbow Ranch Irrigation Modernization Project, is recommended for immediate funding. The other 3 projects are provisionally recommended contingent on the department receiving additional funds after a scheduled May 2026 lottery revenue bond sale. These are the 2 projects that are not recommended for funding by the TRT at this time. Neither project met the minimum score of 5 in each public benefit category. Moving on to irrigation modernization, these are the 2 projects recommended for funding by the TRT. As I noted previously, they recommended funding projects ranked number 1 and 3. This is the second ranked project, which again was not recommended because there are insufficient funds for the amount requested, not because of the public benefits. So after the TRT meeting, we held a public comment period on funding recommendations from October 20th to November 10th. We also reached out again to tribes at this time to invite comments on the funding recommendations and did not receive any comments from the tribes. However, we did receive 8 public comments on the funding recommendations. The first was a request from the Klamath Drainage District to amend their application for partial funding. We also received public comments from 6 organizations in support of the Klamath Drainage District Irrigation Modernization Project, including from the Oregon Water Resources Congress, Modoc Nation, Klamath Irrigation District, California Waterfowl, Sustainable Northwest, and Lakeside Farms. The final public comment we received was from the Madison Ranches, Inc., the applicant for the Field 95 Aquifer Recharge and Expansion Project. And next, I will talk about these 2 projects that we received public comment on that, again, were not recommended for funding by the TRT. Excuse me. I'll start with the Field 95 Aquifer Recharge Expansion Project. It was not recommended for funding by the TRT because it did not meet the minimum score of 5 in environmental or social cultural public benefit categories. After receiving public comment, the department reevaluated this application. So a little bit more about this project. It requested $402,000 and is located in Umatilla County. The project proposes to expand an existing aquifer recharge project near Echo Junction in Umatilla County. It would add 44.3 acres of infiltration basin and install a collector well. Water recovered from the aquifer via the collector well would then support agricultural irrigation, and a portion would be injected into the aquifer storage and recovery well. OWRD groundwater field and PCI staff carefully reviewed the public comments and re-reviewed the technical findings. The applicant clarified that Field 95 has not been farmed for 10 years, aligning with DEQ's guidance against using actively cultivated fields for aquifer recharge. However, questions about Field 95 were not the primary reason the project was not recommended for funding by the TRT. After considering the public comments and reassessing the project, the department concurs with the TRT recommendation to not fund the project. The public comments did not provide new evidence that would warrant a change in the environmental or social cultural benefit scores. The TRT scored the environmental category as a 1 out of 60 and the social cultural benefits as a 4. And as a reminder, a minimum score of 5 is required for funding. For the environmental benefits, The evidence provided only supported localized and seasonal improvements to groundwater levels. Moving on to the second project that we received public comment on, the Klamath Drainage District Irrigation Modernization Project. As noted earlier, the project was not recommended for funding due to insufficient funds. During the public comment period, as I noted, the applicant requested partial funding for their project with the remaining irrigation modernization dollars. This project is located in Klamath County. Their original request was about just under 4.3 million, and their revised request is a little less than 1.5 million. So this project proposes to extend the North Canal by about 0.5 miles to connect with the P1 lateral, creating a new delivery point to the Lower Klamath National Wildlife Refuge. It would modernize the E&F pumping plants to a common voltage, add variable frequency drives, and install recirculation pipeline to the center canal. It would also add SCADA systems at 12 sites for real-time control and measurement across district facilities. During the public comment period, the applicant proposed to reduce the scope of the project and remove installing a fish screen at the North Canal diversion. The department evaluated the request and found that the project will still result in public benefits in all three categories to warrant funding. So as noted by Louisa, the recent changes in House Bill 3364 authorized the department to consider both the TRT recommendations and any public comments received before making final recommendations to the commission. After reviewing both sources of input, the department supports the TRT's funding recommendation and proposes funding water project grants and loans projects ranked 1 through 4 on this slide. This will leave available approximately $2 million for the next water project grant and loan funding cycle, which is currently open and has a due date of January 21st. This is a map of the 2025 applications received for water project grants and loans this funding cycle. Projects recommended for funding are in blue, while those not recommended are in red. And the base layer highlights previously funded water project grants and loans projects by county, providing context for geographic distribution and funding history. Moving on to irrigation modernization, the department recommends funding the projects ranked 1 and 3, consistent with the TRT. For the project ranked number 2, the department recommends funding the revised amount requested by the Klamath Drainage District during the public comment period. This funding recommendation will fully allocate the one-time $50 million received for irrigation modernization. And again, a map of the irrigation modernization projects. These are the 3 applications received in 2025, and the base layer shows the previously funded projects by county. As a reminder, per statute and rule, the commission shall make the final decision based on equal importance of each public benefit category. The awards are to be based on the greatest public benefit and those that best achieve target outcomes, and that are based on changes resulting from the project. The commission may consider the following alternatives today. Number 1, adopt the department's funding recommendation contained in tables 3, 4, and 5 of the staff report to immediately fund 1 water project grant and loan application, provisionally fund 3 water project grant and loan applications for a total WPGL award of $2,390,712, and immediately fund 2 irrigation modernization applications and partially fund 1 irrigation modernization application for a total irrigation modernization funding award of $4,303,179. Number 2, adopt a modified funding recommendation. Or 3, direct the department to further evaluate the applications and return with a revised recommendation. The director recommends alternative 1, and I will not subject you to me reading that again. It is very long. And with that, thank you so much for your time. And Louisa and I are happy to answer any questions.
Great, thank you for that presentation, very thorough. Do you have any questions from commissioners? Commissioner Lee?
Yes, we've gone astray the last couple times and recommended changes, but I think this is really an excellent layout, and I would recommend the commission proceed with what you've recommended.
Thank you. Almost. Commissioner Newman.
Just a quick comment. I don't think I've seen before a letter disagreeing, quibbling with the TRT quite so much as the Madison Ranch one did here. I just wondered if you had any comments on that.
Commissioner Newman, thank you for the question. I think this is, I don't know how to answer this one. Yes.
First.
Okay, this is a first. I will note that our TRT hasn't been a public meeting for very long. So I think starting a year ago, we started having the TRT as a public meeting. So applicants and anyone who would like to watch can. And there are pros and cons to that. So I think we're seeing
Interesting.
just the public process playing out.
Yeah, okay. Otherwise, I thought, yes, very thorough staff report and helpful information. Thanks.
Any other comments from commissioners? Do we have, oh, we've got Commissioner Wolf.
Yeah, I just wanted to echo the ability to take the comment into consideration before the recommendations. I think that's a great thing. Also, not to be difficult, but I will, relative to a personal and business relationship I have with one of the applicants, I'll either need to abstain on the entire motion or have it structured differently. Relative, I don't think it's appropriate for me to have a vote on the Wallowa County Water Projects Grants and Loan application.
Thank you, Commissioner Wolf. So does anyone have any comments related to that? No. Okay, do we have a motion?
So moved.
Alternative.
Pull it back up and should I read it or can we just say
We
that
say alternative.
alternative one is recommended by staff?
Yeah.
I move that we adopt the department's funding recommendation contained in tables 3, 4, and 5 of the staff report to immediately fund one program grants and loans, water projects grants and loan application for $564,800 to provisionally fund 3 WPGL applications, one of $1,825,912 for a total WPGL award of $2,390,712 and immediately fund 2 irrigation modernization funding applications, $2,834,236, and partially fund 1 irrigation modernization application, $1,468,943 for a total irrigation modernization funding award of $4,303,179.
I'll second the motion.
Right, we have a motion and a second. I'll take a vote. Commissioner Chiara?
There. Yes.
Commissioner Mall?
Yes.
Commissioner Lee?
Yes.
Commissioner Newman?
Yes.
And I vote yes. The motion passes. Thank you
so
so
much.
much.
May I ask a follow-up question? Chair.
Yes, Commissioner Mall.
While you're here, thank you for your presentation. Thank you for presenting. I think this is the first time you've presented in person to us, which I know we're kind of a goofy bunch, so it can be kind of hard. we've talked in the past about discretion and foreshadowing some of the conversation I think we'll have this afternoon about the Harney, and I've mentioned this before. I wonder if in the work with legislature or internally to date, you all have given any additional thought to ideas we've floated in the past, similar, for example, to the OWEB board having a focused investment program where they're proactively saying, we want to set aside a portion of the grant program for this particular geography, for this range of things. And I will make a similar recommendation this afternoon that in implementation of the rule that we look to the grants and loans program as a potential source for that. And I'm just curious if there's been any anticipation of how we might be able to implement that within the rules of the program currently.
Thanks, Commissioner Malt. We have had some discussions internally in our grant team, but they're very preliminary at this point, I would say.
Then I encourage you to
But we will continue that
have some
conversation.
between now and
Thank you.
2 o'clock this afternoon.
Oh, and 2 o'clock, okay. We have
Thank you.
we have talked about it for our water measurement cost share program in particular and what we can do with that program
Good.
for the Harney.
I'm particularly interested in things like with a voluntary agreement group coming together for a particular geography. Could they somehow be an applicant? Could someone apply on behalf of a voluntary agreement collaborative, for example? Don't know, but those kind of nuts and bolts questions. So thank you.
Thank you.
Thanks for continuing to wrestle with that.
Interesting thought, Commissioner Mall. Thank you for your presentation. We do have a couple people signed up for public comment. So I will first call up Scott White.
Now it is. Well, thank you all, Vice Chair Smitherman, members of the commission. You guys are not going to get off that easy. I had a 22-minute presentation for you. But since you already made the motion and passed it, I'm just going to spend my time saying thank you to you all. I really appreciate it. My name is Scott White. I'm with the Climate Drainage District General Manager. So once again, thank you. And I especially want to thank Director Gall and his staff. They have been fantastic working with us in talking us through how to do the amendment process and make that all work so that we could continue doing some good work down on the district. So thank you all.
Thank you. Thank you, Scott. Appreciate that. Commissioner Mall? No?
Wonderful to have you here. I'm interested in the portion of the budget that was removed for the fish screen because this is coming at a time. I don't know if it's in the Central Canal or not, but it sounds like salmon rostrums are butting up or should be butting up against screens, but are showing up in canals now. I mean, it's brave new world. Is there another route that you all are taking to secure that, or is it are you putting it off from phase standpoint? Are there other federal or state funds that you're pursuing for that? Private funds?
You're going to put me back into my 22-minute presentation here.
How about two?
Yes, fish returning in our neck of the woods up there is definitely something that we're dealing with. I'm a fish guy now. We do have fish did have fish in our canals. We were the ones that really kind of blew the whistle on that, if that's the term to use, but sent the press release out. I think you may have seen me on the news. I was on KGW a couple of times is what I heard. But point being is we've been kind of screaming about fish screens for a long time, hence the reason why we introduced the fish screen in this watershed plan for NRCS. But being so that we could utilize these funds, it didn't fit because of the price tag of it. But I mean, with the bad, and I don't necessarily want to call it bad with fish coming back, but there is good that comes with the fish getting in our canals, and it has gotten a lot of really, really positive attention and people wanting to help. And so I take a call almost daily about how folks can help grant opportunities. So I do see future funding opportunities for fish screens in the very, very near future. We also have a 5-screen project underway already with ODFW and Oregon Lottery dollars, as well as some Bureau of Reclamation dollars. And so those are moving, should be installed in 2026 if I can keep the fire under the feet. But I'm confident that you know, the fish aren't going away anytime soon. And so I'm confident that the money will continue to find a way into the basin for these screens. So sadly, it's a little too late in my opinion, but it's finally happening.
Good. Let us know how we can support that.
I appreciate that. Thank you.
I just had a comment. This is just a really good example of how applicants can work with the department to amend an application. I really appreciate the department taking that effort and helping applicants figure out what they need on their applications or what the funding limitations are, and working with the applicant to at least secure some type of funding to help with a project moving forward. So I do appreciate that that's part of our process, and glad that we were able to help out your basin.
Thank you.
Any other questions or comments? Thank you.
Thank you.
Next up, we have April Snell.
Hi again. For the record, April Snell, Oregon Water Resources Congress. Just want to make a few comments in relation to the funding decision you guys just made. Pleased to say I agree with the decision and appreciate the work of staff to again address the needs of Klamath Drainage District, which you just heard from Scott about. Our letter of support for that project is in your packet. I just want to add a couple thoughts. One before I forget. Welcome, Louisa. Great presentation. Our association and myself personally were involved in the development and passage of Senate Bill 839 in 2013 that created the Water Projects Grants and Loans Program. And then we also were involved in advocating for the $50 million from the 2023 session for the irrigation modernization funding program. And I think as we're going into the resource constrained fiscal environment, it's going to be really important to show that these projects are successful and provide multiple benefits. And I'm glad that in the instance of the irrigation modernization funds that we're going to get all of that money out the door. And I think that will strengthen opportunities for us. And I'm committing myself and our association to continue to advocate for funding for these types of projects. And it is something where I do feel there's value there, and hopefully we'll be able to get some additional funding there in a future biennia. But I think in this instance, it made a lot of sense to utilize the last drops of the funding that you can. And I will say that you have our letter of support for Klamath Drainage District's project, and again, commend the staff and their ability to pivot and amend that. And then I also do want to mention that Lone Pine Irrigation District is also one of our members. And while it wasn't up for debate, we're also very supportive of their project as well. And I think that it's going to be important for all of us in our different roles and capacities to talk about the value of water from an economic, community, and environmental perspective, as you heard from Ms. Burright earlier, and talking about other agenda items. Natural resources are perennially underfunded and overcut in these types of situations. And I think these types of projects, particularly now that we have geographical diversity in projects that have been awarded, that there's a powerful story to be told there. And that's both that we need grant funding to support these types of projects and leverage federal money when it's available, but also that we need staff and people like the ones next to me to make sure that we can implement all of those programs. So again, I really appreciate your decision. Look forward to there being more money in these accounts in the future. And I do think that when we get to that point, it is something to look at, well, how can we improve our existing funding programs, make them more nimble when there is federal funding, address some concerns that might come up from the technical review committee process. But I think overall, you guys have done a great job, and just really appreciate your consideration and supporting district projects. So thank you.
Great, thank you, April. Any comments, Commissioner Lee?
Yes, this is a question to you, April, as well as to staff. Should I start over? This is a question to you, April, as well as staff. I know there was $50 million committed by the legislature, but I'd really be interested to take a look back to the beginning of the program and identify how much federal money came into that program. Maybe that's something that we can come up with an answer for later.
Commissioner Lee, members of the commission, this is actually something that came up in recent conversations with Director Gall actually this week, and it is something we're very interested in being able to have those data points to be able to tell the story of success. I don't have the number there, but happy to work with the department and maybe you'd have an answer there.
Sorry, I didn't mean to cut it off. Commissioner Lee, thank you for the question. So we do track how much match is coming in and by and what is the source of that match. So we do have all of those numbers, but not compiled at the moment to easily get for you. And I will just note that we have invested in a grant management system that will make getting that answer so much easier in the future. So I'm very excited about that. But if you're interested, we can find that number for you and get back to you.
Great. Thank you. Any other comments? Right. Thank you so much for your presentation. Thank you, April. Okay, we got, you can see, I know lunch is soon, but we have agenda item C first. So agenda item C is commission appointments to the Groundwater Advisory Committee. Justin.
Oh, red is good in this case. Yeah. All right. Vice Chair Smith and members of the commission, for the record, my name is Justin Iverson. I manage the groundwater section here at the department. And agenda item C is appointments to the Groundwater Advisory Committee. Come before you every year, this time of year, with a new slate of candidates to keep the committee fully staffed with good folks. Okay. Just real quick summary of the authority and purpose of the Groundwater Advisory Committee. It's a 9-member committee where members represent a various range of interests in groundwater, a various range of expertise, and a various range of areas within the state. We appoint people to the committee for 3-year terms, and we have a standing policy from the commission of a 2-term limit on members to the committee, so they can serve for 6 years total. The purpose of the Groundwater Advisory Committee is to advise the commission on any rule-related items related to groundwater, as well as to provide advice on licensing and examination of well drillers. The committee also reviews expenditures of the Start Card Fund. That's well drilling start cards that are a source of fee revenue for the department. So this year we have 2 folks on the committee with expiring terms. Brandon Brown, a well driller
from the Umatilla area, as well as Ken Bentz, a groundwater irrigator in the Crane area that's in Harney County. They're both coming to the end of their first term. They are both interested in continuing on the committee. So that's great. Made the annual process a bit more streamlined this year. We do have a rolling application process, so folks can express interest in serving on the committee at any point in time through a letter of interest to the director. All that information is up on our website. We typically attempt to kind of make active solicitations, especially when we have folks coming off the committee, just to advertise the positions and make sure folks know. But this year, we did not post any active solicitations since we knew that we had folks that were interested. We did not get any new applications in 2025, though I will note that last year we had more applications than we had open spots. And so we did check back in with those folks, let them know what the situation was, and we are keeping them in the wings, so to speak, for next open position. So the two current committee members coming to the end of their first term did put in new letters of interest. So spoke with them and had a very known evaluation. So nominations for 3-year terms beginning today and extending through November 30th of 2028 include, again, Brandon Brown from the Umatilla area as a representative of the monitoring and water well industry, and Ken Bentz, groundwater irrigator from Crane. Alternatives are to appoint those two folks for GWAC terms that are listed there, or you may direct us to return at the next meeting with another slate of appointments that might reflect a different set of interest categories or geographic areas. So with that, director's recommendation is number 1.
Hey, thank you, Justin. Appreciate the presentation. Do we have any comments or questions or a motion? Go ahead.
I would move that we appoint Brandon Brown and Ken Bentz to Groundwater Advisory Committee term beginning December 11th, 2025 through November 30th, 2028.
I second the motion.
Okay, we have a motion and a second. Let's go ahead and vote. Commissioner Wolf,
Yes.
Commissioner Lee,
Yes.
Commissioner Newman,
Yes.
Commissioner Kihara,
Yes.
Commissioner Mall,
Yes.
and I vote yes. Motion passes. Thank
Okay.
you, Justin. Thank you for your work.
Sure. Thank you very much.
Okay, agenda item lunch will commence. Thank you. We will be reconvening at 1 p.m. Thank you all. Welcome, everyone. We're going to reconvene our Water Resources Commission meeting, and we will be moving on to agenda item D. And I just wanted to mention that we did get several late filed comments that were beyond the public comment period. And unfortunately, those cannot be considered in our deliberations or any of the decisions that we make on the rules. And I just wanted to mention that ahead of time. I believe we have some comments from Director Gall to kick us off. Director Gall, when you're ready.
Vice Chair Smitherman, members of the commission, greetings. I do have some opening comments here for this agenda item. I'll go ahead and go through those and then turn it over to the team for their introductions and the presentation that they've prepared for us here today. This agenda item represents a significant milestone resulting from much work over many years in the Harney Basin. The presentation today is a continuation of the Division 512 rule process, of which you heard many details in September. The proposed rules were changed in response to public comments and the input received. We think the groundwater management approach and the proposed rules balances timelines of needed action, minimizes impacts to users while still being consistent with statute. Groundwater level declines in the Harney Basin led to a classification of groundwater for exempt uses only in 2016. Also, a multi-year basin and recharge study with the U.S. Geological Survey, a significant work with our staff and the Department of Geology and Mineral Industries to compile geologic data, prior reports on geological mapping, and map in more detail the geology of the basin. We supported place-based water planning for the basin and have implemented financial incentives provided with the support of the legislature for water users to retire their groundwater rights and help residents in the basin with dry or declining wells. The last 2 years have been spent updating and writing these rules to establish a long-term groundwater management approach through use of critical groundwater area authorities, our serious water management problem area authority, updating the basin classification boundaries, and support for agreements for voluntary reduction of groundwater use. The proposed rules in front of the commission today represent the department's preferred alternative with the intent of stabilizing groundwater level trends within the proposed critical groundwater area by 2058. The rules are supported by significant scientific data and analyses and are also much informed by and reflect the input of the diverse RAC community conversations throughout the basin, an extensive public comment period, and the petition submitted to the commission on September 12th. The many public comments, the petition to the commission, and the proposed legislation last session indicate that not everyone agrees with the proposed rules. At its core, the management approach in the proposed rules allows for the minimum amount of groundwater use reduction to achieve stability in groundwater level trends as defined by the proposed target water level trend in the proposed rules in front of us today. There are many other groundwater use reduction options that represent different combinations of timing, location, and amounts, all of which would result in different outcomes of water level trend changes over time. Generally, less reduction in groundwater use equals less economic impact, but would not likely achieve stability at all or not in the proposed 30-year time frame. Alternately, rapidly reducing groundwater use would have the benefit of more quickly stabilizing groundwater level trends, but would have more negative economic impacts to those using groundwater. The community, our agency, and many others have put in the work over a 10-year process to develop an approach that can effectively stabilize groundwater over time. The economic impacts that could result are real, as are the consequences of inaction. Our goal has been to learn as much as we can, give the community meaningful opportunities to engage and shape our future, or our approach, and then deliver rules to you that will achieve resource stability for future generations. Your input and feedback to us over the last 2 years has also helped inform our approach. This is not the end of our work in the basin, nor the end of this conversation. We will continue working with the interested parties in the basin and will use the tools available to us to support this transition in upcoming years. We will continue supporting the Conservation Reserve Enhancement Program, our Well Assistance Fund, and helping water users with our Water Use Measurement Cost Share Program, as well as supporting voluntary agreements and the sharing of data and information to support assessment of new ideas and possible solutions. So thank you for all of your work and support, and I will turn it over to our team for their presentation.
All right, Vice Chair Smitherman, members of the commission, appreciate the time this afternoon. We are going, for the record, my name is Jason Spreet. I'm the East Region Manager for Water Resources out of Baker City. And I'll go ahead and let the panel introduce themselves.
Vice Chair Smitherman and the commission. For the record, my name is Kelly Mines. I'm the water policy analyst and the rules coordinator for this process.
And I'm Tim Seymour. I'm the assistant manager for the groundwater section here at the department.
All right, with that, I just real quickly, I just want to recognize, as Director Gall, I think mentioned in his comments, but also, the staff really want to call out that, we really appreciate all of the RAC time and comments and the public comments that have impacted the rule language. And I think, we've come to a point where we do have a good balanced approach here. I also want to recognize the team's work, all of our groundwater team, the gentleman here with me on this panel, and all the work the rest of the team has done on these rules and this very difficult process. So today we're going to go through this presentation. Next slide, please.
All right. There it is.
Just a quick outline here. We'll talk a little bit about the rulemaking background. We'll go over the process of the Division 512 rulemaking, the summary and the themes of comments, all of the rule language changes that were made, the quick amending cost compliance, and then also we'll get to the end of the presentation where we'll present alternatives for the commission to consider. And with that, I'll turn it over to Kelly.
Actually, it's going to be me.
Oh, sorry, Tim. Sorry.
It's okay. We're interchangeable. I'd say as Ivan talked about, and as we've presented at past commission meetings, a lot of this work, it can, or a summation of the problem that we face can be found in the groundwater report that was produced for this critical groundwater rulemaking process. And that report was published and we discussed it at the September commission meeting. So I don't want to spend a lot of time on that, but we're going to run quickly through a few of the key points here. And a reminder that that report is really intended to be a statement of the problem that we're trying to deal with, defining the groundwater reservoir that we're proposing to designate, identifying the statutory criteria that have been met that authorize the designation of a critical groundwater area, and then moving on to the strategies that we're proposing and the corrective controls we're proposing here in the rules. As a final statement on that report, I want to remind the commission that it is based on our best available science and information that comes from that collaborative study with the USGS over that 6-year time frame, and includes a number of publications, including the Harney Basin groundwater model and associated reports. So when we talk about the groundwater reservoir, you've seen this slide many times, and we've talked about it many times. The collaborative study found that there's one groundwater reservoir within the Harney Basin, and it is coincident with the Harney Basin hydrologic boundary. Within that groundwater reservoir, groundwater occurs in multiple connected geologic units or rocks, and water within those different types of rocks behaves differently based on the types of rocks. The geology affects the way the water moves. And the last point is that rates and magnitude of recharge and discharge vary based on location. So even though we see different behavior in water levels and different behaviors related to recharge and discharge, there are no known boundaries to flow throughout the basin, and it is one contiguous groundwater reservoir. And that is what we lay out in that groundwater report. When it comes to the groundwater conditions that we're facing in this basin and that we're trying to address, there are 3 that have been met, 3 statutory criteria that have been met. The first one is that groundwater levels have declined excessively, and that means that there is greater than 50 feet of total decline in wells within portions of that groundwater reservoir. We also have wells that are excessively declining, and that means groundwater levels are declining at a rate of 3 feet per year or more for at least 10 years. And the last point, as we've talked about in the past, is that the available groundwater supply is being or is about to be overdrawn within portions of the groundwater reservoir. And that overdrawn condition means that pumping exceeds recharge. And when that occurs, it's a very serious situation because pumping is consuming all of the groundwater recharge and leaves none for natural processes like discharge to streams and springs or discharge by native vegetation in the form of evapotranspiration. And so we have these 3 conditions that have been met, and they're called out in that critical groundwater area report. And so then we have 3 strategies that we're proposing in order to resolve this problem and address it. The first is we intend to protect recharge through these proposed rules. And we're doing that by classifying the groundwater reservoir for exempt uses only and non-consumptive geothermal. This ensures that no new groundwater uses can come online, and that the existing recharge will be protected for current groundwater uses. The second item here is that we are proposing to reduce groundwater use by implementing a critical groundwater area and its associated corrective controls, limiting groundwater use and reducing groundwater use within that critical groundwater area boundary. And the last strategy we have here is that we believe we need to achieve accountable groundwater use. And we're doing that by requiring metering and reporting through a serious water management problem area designation. Those are the three strategies we've laid out in our proposed rules and that you will see as you read through those proposed rules. So now I'm going to turn it over to Kelly to talk about our Division 512 rulemaking process.
Thank you, Tim. So for the next several slides, I'm going to take you through areas of input that really help craft the proposed rules that were noticed for the rulemaking. And then I'll go through the public comment and discuss the themes of comments. And then we'll start talking about changes made to rules based off comments received. So if we can go to the next slide. So during the rulemaking process, prior to the public comment, right, we had 4 areas of input that really helped shape the noticed rules. The first would be the Rules Advisory Committee meetings. Then we had discussion groups. We had coordination with affected local governments and tribal coordination and consultation. Those last 2 areas are very specific to Division 10 and the requirements that the department needs to follow, and more on that later. But first, let's get into the Rules Advisory Committee. We had a fairly large group of people help us out during the Rules Advisory Committee, and we had 32 RAC members, and they were consisted of the Burns Paiute Tribe, county governments, irrigators, ranchers, well drillers, domestic well owners, water rights experts, consultants, local small business owners, environmental organizations, and the Mahi Lake Wildlife Refuge. And our goal when forming these RACs, this RAC, was to have a Harney County centered RAC, as many community members represented that RAC. And we had 29 of the 32 either live and work in Harney County or in Grant County. In March 2023, we did a week-long engagement in the county, hosting like informal conversations, attending community meetings, really with the goal for 2 things. The first was to get volunteers to be on the RAC. Let the community know that we're starting this rulemaking process and we are looking for community members to help voice and make changes to these rules as we go through the process, and to also get people to sign up for our notification about so they can be brought along what's happening in the rulemaking process. Once we formed the RAC, we did 15 RAC meetings over the course of 2 years. So April 2023 to May 2025. These meetings were professionally facilitated. 13 of the 15 meetings had a professional facilitator. We added a professional facilitator upon request of the RAC. They felt like a professional facilitator was needed, and we agreed. So in addition to this facilitator help us in the meetings, they also went after the meetings, talked with RACs, kind of took surveys, and then fed us back that information. And we took the input from both the RAC and the fed back information, and we adjusted our plan and our management plan. Throughout these 2 years, it was a very iterative process. We bring back our plan, we take comments, and then we adjust that. And out of the 15 RAC meetings, there were really several key elements that were included in the notice rules based off input. The first, I would say, and probably the biggest one, is that we are focusing on stability over recovery. So requiring smaller groundwater use reductions, right? If we were to go for recovery, then we would have stricter groundwater reductions, being more impact to that community. We are also spreading these reductions over 24 years, providing certainty and adaptability to water uses in the Honey Basin. We went from our originally proposed 15 to 7 sub areas to increase the flexibility and broaden participation in voluntary agreements. For the first time in the department's history, we've written in an adaptive management framework into the rules that allows us to adjust reductions based on ground level trends. We have defined success as 50% of the wells need to meet stability, Originally, we were planning for 80%. So upon conversations, we went to 50. And then lastly, but certainly not least, we're curtailing based off of actual use and not paper water. And what that allows us to do is we give water to what they're actually using, and whatever's left on that paper water, right, gets pushed down to the next junior user, resulting in less junior users being regulated off. So if we go on to discussion groups. So discussion groups were kind of formed because they're starting to be a kind of a, how should I say this? The community, we started to kind of get a sense that the community needed more time outside of the RAC to really discuss these difficult conversations and topics that were happening in the RAC. And so these discussion groups, this is the first time the department's done this. We partner with Oregon Consensus. Bobby Cochran and Harmony Burwright facilitated these meetings. And these were meetings completely independent of the RAC, and they were community-led. The intent was to really promote transparency during the process and give community members and RAC members to really discuss this. We did 14 of those meetings, and discussion groups were formed recommendations, and those recommendations would be fed back into the Rules Advisory Committee. And a good example of a recommendation was a reduction from 15 to 7 sub areas. We had a 2-day in-person meeting, discussion group meeting, where we talked about boundaries with sub areas. And that recommendation was brought into the notice rules and the rules you see today. Coordination, back to local governments. So this is a specific Division 10 requirement. And what Division 10 says that we need to do is, 1, prior to the Rules Advisory Committee, we need to initiate coordination. And 2, to help with that coordination, we need to provide the draft critical groundwater report that Tim talked about earlier. An exception was made for Division 512 because Division 10 had not been adopted yet when we started Division 512. And that exception was that we need to start coordination and provide that draft report no less than 60 days prior to public comment. And so in fulfillment of those requirements, we posted the draft report on June 21, 2024. We sent it to Harney County and to the city of Burns and Hines. We invited them to meet with the department, discuss the groundwater management plan. For Harney County, we met with the county commissioners on April 15th and 24th, 2025. And they were also included in the RAC. They were a part of the RAC for all 15. In terms of City of Burns and Hines, we did not get a response on an invitation to discuss. We invited them to volunteer to be on the RAC, and we did not get a response. Tribal coordination and consultation. So again, this is another Division 10 requirement. We either need to do coordination or formal government-to-government consultation prior to the RAC. And the exception is there, so we have to do it no less than 60 days prior to the rules. So in fulfillment of these requirements, on December 16, 2022, OWRD invited all 9 federally recognized tribes to engage through staff-to-staff coordination, including RAC participation and or government-to-government consultation. Again, on June 21, 2024, we provided that draft report to the Oregon 9 tribes inviting coordination and consultation. And specifically with the Burns Paiute tribe, we had we started the RAC with the Burns tribal representative serving. We offered engagement outside of RAC participation, and we fulfilled that government-to-government consultation, which we had meetings on August 12th, 29th, and September 29th, 2025. And then a follow-up meeting October 15th outside of the public comment to give a briefing. So all of these areas of input helped shape the notice rules that were sent in for public comment. And as a reminder, in our September meeting, Tim and Jason took you through kind of a deep dive of what was included in those rules. And so here's kind of the highlights. So we're classifying for exempt uses and non-consumptive geothermal uses. In terms of the critical groundwater, we're dividing the basin into 7 sub-areas. We're establishing the allowable pumpage for each, the permissible total withdrawal. We're defining a process for allotting water to each right. We're defining a process for scheduling reductions to the PTW. And we're establishing a process for adaptive management, as well as requiring metering and reporting with our SWAMPA. We had a pretty extensive public comment period to allow for lots of input into those proposed rules that we noticed. We had 6 informational sessions, 10 public hearings. We extended the public comment twice, one from August 7th to August 12th, and then the other one from September 22nd to September 17th to October 12th. Thank you. We in total received 260 written comments and 68 oral comments. The petition for rulemaking is concluded in that written comment count. And then when you look at the forensics of those written comments, we had about 1,157 individual comments. Not a lot of repeat or forms. They were all unique comments. And I just for a minute want to, for those 6 informational sessions, we held them out through the entire basin in different sub areas. And I really want to thank High Desert Partnership. They were instrumental in getting us the venues throughout the basin, and I don't think we could have done that without them. So thank you to High Desert Partnership there. We also had a special GWAC committee meeting, so they can form recommendations to you. So on your screen are these recommendations. So I'm just going to read them to you. GWAC agrees that there is a need for correct controls to reduce groundwater use. The proposed tools, classification, critical groundwater area, and SWAMPA, or Serious Water Management Planning Area, are appropriate and provide additional advice on critical groundwater boundary. Majority supports that. The boundaries for implementation of classification of SWAMPA are appropriate. The basin is one hydraulically connected groundwater reservoir, but the committee has questions about the Upper Blitzen area being included in the critical groundwater area. More on that later when we talk about changes. With 6 of the 7 sub-area designation, Upper Blitzen is the exception. Using the USGS numerical model of the Harney Basin to determine PTW and minimize economic impacts was appropriate. Got 1/2 more slides here. So the adaptive management framework is very important inclusion in the proposed rules. An initial PTW designation based on water right duty of 2.5 acre feet is appropriate. Actual wet water use is appropriate benchmark for initial allocation. A 30-year implementation timeline is appropriate for balancing community economic concerns with groundwater level stabilization. Target water level trend, as stated in rule, is a good starting point. GWAC additionally recommends acknowledging and accounting for outliers. Next slide, please. And then finally, GWAC recommends the Water Resources Commission consider voluntary agreements to increase flexibility of water use within the sub areas. So in September, I talked to you about all the different themes of comments that we received. So on the screen, it's just kind of a reminder of those themes of comments. Since then, we've had 1 additional public comment phase. And the comments that we received during that public comment phase all kind of fit within these themes, except for one, and that was on the petition for rulemaking. So those comments were we support or we do not support the petition for rulemaking. You can see all of our response to the comments in attachment 13. And now what we're going to do is we're going to take you through all of the changes of rules based off of the comments that we received. And I'm going to go ahead and pass it over to Jason.
All right, thanks, Kelly. So we received a number of great comments and we made a number of changes to the rules. One of those is the definition of regulated off. The department received a comment recommending that the department add a definition for regulated off and reduce to ensure there's no question about the legal terminology related to limiting water use and the intent of the rules. So the change that was made is that we added a definition of regulated off and reduce to indicate that this is an action taken through a regulatory order. And the reason behind that just provides some additional clarity for folks regarding the process of water use reductions. So, and then under the target water level trend rule, we received comments recommending that the department should extend the period of data used to calculate the groundwater decline rate. The department agreed with that and instituted a change where the target water level trend is calculated. So the groundwater level decline rate is calculated using 6 years of data instead of 5 years of data. And that matches up with the timelines for adaptive management. So that was the reason behind making that change there. Is it just, for consistency, we wanted to line those timelines up with the adaptive management checkpoint timelines. And then under the initial allotment section, this was an agency initiated change where in the noticed rules, the allotment included evaluation of each water right in the proposed critical area to determine actual use through analysis of applied water. So what we were looking at in that initial approach was just looking at each and every water right in the critical area, determining how much applied water there was for that particular water right, and then allotting water based on that applied water number. So we have found though, in looking at some of those, that the applied water varies greatly from field to field based on access to water, the crop type, even the slope of the field makes a difference in, some of those calculations. So we took a step back and we decided to make the change that would just allot water a maximum of 2.5 acre feet for each acre that's beneficially irrigated in that time period between 2020 and 2024. So what we'll be doing is just looking at each water right, looking at the irrigated area, and if it appears to have been irrigated in those years, then we'll allot 2.5 acre feet for each acre on that water right. And the reason for that is provides more certainty when quantifying the total allotment of water, and it does not punish users that have invested in highly efficient irrigation methods and maybe using less water. So multiple stub areas. So we received a number of comments where the department, it was suggested the department should clarify how rights with points of appropriation in more than one sub area will be addressed. So there are a few cases where a water right has point of appropriation in multiple sub areas. And the change we made to address that was we will specify that any water right with points of appropriation split between 2 or more sub areas will be subject to the rules applicable to the sub area where the majority of those points of appropriation will exist. And that will provide some clarity for the water right holders around what sub area rules will be used to manage their water right. Also, we got a number of questions regarding the Upper Blitzen and the permissible total withdrawal, and they suggested that we remove Upper Blitzen from the critical groundwater area. The change that we made in response to that comment was that we did remove the permissible total withdrawal number for the Upper Blitzen subarea from the rules. And the reason behind that is we feel that the critical area goal can still be achieved without that reduction of use in the Upper Blitzen. But we did want to keep it within the critical groundwater area boundaries because that will help prevent new, prevent new water right applications in that sub area. And then we also heard that the rules should include a mechanism to rescind reductions if recovery occurs. While the best available science indicates it's unlikely that groundwater levels would recover to certain thresholds proposed, we did make a change such that 10% of the reductions implemented can be rescinded if at a management checkpoint the water levels recover above 2028 median water levels in that sub area, and also no wells in that sub area are meet the threshold of declined excessively or excessively declining. We felt that it was appropriate to include that path to rescind reductions, although again, the science we have indicates that is not likely. We also, under metering and reporting requirements, this is another agency initiated change where we wanted to clarify language. So we added language detailing what it means to disconnect or decommission a well from water use infrastructure. And the context behind that is, while we are requiring metering and reporting for every valid point of appropriation, there are cases where if someone wanted to disconnect their well and infrastructure, then they would not need to meet that requirement. So we wanted to make that clear, and we included disconnecting from power and plumbing to clarify that. Also, we removed a check-in that was for 2027. And so previously we did an evaluation and we had an evaluation in 2027 that would pause corrective controls in 2028 if the target water level trend was achieved and the water levels were at or above 2022 levels. So we made that change. We removed that check from the proposed rules in favor of an alternative that would delay regulatory reductions for the subareas with the least severe groundwater declines. And the reason behind that is that we feel like that change allows users an opportunity to develop voluntary measures to delay those corrective controls and set some clear targets for those voluntary actions. And so, as I mentioned on the previous slide, delaying reductions in the Sylvies, Silver Creek, and Lower Blitzen voltage subareas. We heard a number of comments regarding the delay of reductions in subareas where groundwater levels show minimal declines. This was also part of the petition that was submitted to the commission. And we made the change so that if a 10% voluntary reduction is in use compared to the 2018 estimated use numbers occurs in the Sylvies, Silver Creek, or Lower Blitzen voltage subareas prior to 2028, then the reduction will be delayed. The groundwater levels will be assessed at each adaptive management checkpoint, and if levels are on or above the trend needed for 30-year stability, reductions can be delayed. If they are below that trend, then reductions will be accelerated as is laid out in the adaptive management portion of the rules in 512-0080. Also want to point out those, as I said, those changes were present in the alternative petition. And we felt that these changes still capture the intent of the petition while still achieving the goal of stability within 30 years. So the reason behind that is it allows users to address declines through their own self-management, which we heard a number of times, and voluntary approaches will be, evaluated for their effectiveness based on actual, groundwater measurements and groundwater trends in each subarea. Another thing that was also included in the petition and a number of other comments, as well as consultation with the tribes. The department agreed on these concepts, and so we wanted to change the rules to reflect these concepts. And so we explicitly exempted any state issued groundwater rights or federal reserved groundwater claims held by the Burns Paiute tribe from corrective control measures and the water use measurement and reporting requirements. The reason behind that for the tribes is that we wanted to honor and recognize the sovereignty of the Burns Paiute tribe by exempting these rights or these rights from the rules. And finally here, another adaptation that we pulled from the commission or from the petition document was that we, and also we heard from municipal and quasi-municipal users that we should exempt them from any corrective controls to avoid restricting growth for those communities. So we made the change that municipal and quasi-municipal uses are exempted from corrective controls. And then also the water used but under those municipal and quasi-municipal rights will be accounted for in reductions at each checkpoint. The reason behind that is it recognizes again and prioritizes the unique status of municipal and quasi-municipal rights, providing water for human consumption there. So with that, this time I actually will turn it back over to Kelly.
Thanks, Jason. Just real quick, on the next slide. We did receive a public comment on our cost of compliance that was filed from those rules. That was missing impacts to other state agencies within the critical groundwater area. So in your staff report, there's attachment with an amended cost of compliance identifying that the Department of State Lands and the Department of Veteran Affairs will have a cost of compliance because they are within the critical groundwater area. We just wanted to make you aware of that.
So now we're going to move into alternatives for the commission to consider. And I want to start out first by talking about land use considerations. So throughout this process and the public comment period, the department staff have evaluated land use considerations related to the statewide planning goals. And it's the department's or the department's recommended rules are based on a finding that the rules comply with statewide planning goals. Because those rules will protect important groundwater resources, and that's consistent with statewide planning goal 5. Just want to make that very clear for the commission that we have done that work. And now to round things out, I want to turn it over to Director Gall to talk about why we believe we should adopt these rules.
Vice Chair Smitherman, members of the commission, again, Director Gall with the Water Resources Department. So we're at the culmination of all of this work. And it's the agency's position that we've developed a robust multi-year rulemaking process here and have gone through that. The whole process has been informed by very thoughtful input from the RAC and the public. We believe we've achieved a balanced approach to get to stable water levels and a sustainable use within a generation. And then how to ensure the groundwater is available for the current and future Oregonians is really the ultimate goal here. It's easy to put out words there like sustainable, but to actually implement those takes some hard work. Next slide. So in front of you today, the commission may consider the following alternatives. I'll go ahead and read these. Adopt proposed Division 512 rules as proposed in attachment 15. Including the findings recommended by the department in support of adoption. Alternative number 2 is adopt proposed Division 512 rules as proposed in attachment 15 with modifications. And then alternative number 3 would be to do not adopt proposed Division 512 rules, directing staff to return at a later date with a revised version of the rules for commission consideration. It's the director's recommendation for alternative 1 to adopt the proposed Division 512 rules as proposed in attachment 15, including the findings recommended by the department in support of adoption. And so with that, Vice Chair, I'll turn it back to the commission and yourself. Staff and myself are available for questions or to support any discussion that you may have amongst the commissioners.
All right, thank you. Thank you for the presentation. I thought that was good summary of all the work that's been going on, which is quite a lot over the past several years. Thank you, Director Gall, for your input as well. Do we have any comments or questions for staff? Give everyone a minute to just think for a second.
Yes.
The answer is yes. Oh, yes. Go ahead, Commissioner Wolf.
Yeah, I was just curious, with as much input as was given on this and as long as it has taken, it just kind of occurred to me that like stopping the public comment period when we did, what within the public process, did we miss anything by not reopening it after the department had its final proposals in attachment 15? Or do we not think that there would have been any substantive changes to have come from that? I do understand we've been working on this a long time, but I just wonder if we got close but didn't slightly miss the mark, or if we are where we want to be. Thank you.
Vice Chair Smitherman, members of the commission, and Commissioner Wolf. We don't know what we would have missed from additional public comment. The state of Oregon's rule process is run in a fairly prescriptive manner. There's a lot of boxes that need to be checked there. And then there's a reality of having to move a process forward and get a final set of proposed rules in front of the commission. And so when you think about it, it could be an endless do loop of opening the public comment period, perhaps making modifications to the rules again, getting those in front of the commission, or alternatively, making the modifications to the rules and opening up the process for additional public comment and repeating. So I don't have an answer for you as to what could have been missed with additional public comment. We believe we afforded the process ample opportunities for public comment, both before the proposed rules were put forward and then during the actual public comment period there as well. So I hope that helps kind of answer your question there, but it's hard to say what additional feedback we would have received had additional public comment been allowed for more process there.
Okay, thank you. Yeah, I just have trouble not putting myself in this situation as an irrigator, somebody who runs a business very similarly to many people that are going to be affected in the Harney Basin. And yeah, as I told you in our pre-meeting check-in, I've really struggled with this one. So I hope we got it right.
Clarification, did we extend public comment period twice? Is that right?
Correct. Yes.
Okay. So we did try to pull in as much public comment as possible by allowing an extension twice.
Correct. And I, Mr. Smithman, I would also say, I can't speak to what we might have received afterwards, but in those two public comment extensions, we were receiving the same themes of comments. So that's the only thing I can speak to what I know. So I'm not sure what happens in the future.
Commissioner Lee?
In changing family property values, et cetera. And there are a couple things that I'm thinking we still might be able to do either as part of this rulemaking or after the rulemaking is placed. And one of them is looking at allowing adequate time for voluntary agreements, especially when still and listening. And another thing would be to done some more modeling demonstrations fairly quickly. I think some of those things would actually more than the contested case hearings and litigation. And I'm wondering how far off we are between sub areas that will be in the commission and what you have now provided in 7 and for them to rectify it.
Commissioner Lee, I'll just ask if you can please speak further into your microphone, please.
I'm sorry. Do you want me to repeat? Or did you get it? Okay.
Vice Chair Smitherman, Commissioner Lee, thank you for that question. I know I'll try to address each point, but please make sure to call them back up if I miss something. So Jason and I visited the basin November 20th for a meeting that was hosted by Harmony Burright and a number of groundwater users in the basin to talk specifically about voluntary agreements. And we made it very clear, I hope, at that meeting that we are fully in support of helping with voluntary agreements and doing whatever we can to support those efforts, including modeling as it's necessary. And I believe that we can be helpful there. And I believe that we have addressed the desire to support voluntary agreements in our changes to the rules and offering the opportunity for delay in regulation if voluntary agreements are brought forward that meet that threshold we've set in the rules there. As it relates to boundaries, the petition's boundaries, there were essentially 5 areas in which they were that they proposed within their boundary map. And our proposal has 7, and that's different. And there were 2 key places where we differ, and we looked at those in depth. Internally, we had Darek, our groundwater scientist, digging into that information and walking us through again, because I'm not a groundwater scientist, I'm not as in the data, but we walked through it as a team at least 2 or 3 times having the conversation about why is the boundary where it is in our proposal versus where the petition placed it. And we believe that, again, our boundary is the most defensible boundary we can draw based on the best available science and information that we have. The second piece there is, and really, again, I guess what I want to point out there is that our boundaries are based on, three primary criteria, and those criteria are science-driven and science-based. And that's, again, to group wells together that have similar behaviors and similar outcomes. And we look at the subsurface material. So what is the geology? What does that look like? We look at groundwater level trends. So how are wells, what are their water levels and how are they changing over time? And then we look at hydraulic gradient, which is that, driving force of groundwater flow. And so with those three primary things together, we believe our boundaries are the most defensible for what we can move forward with for regulation. So did I get all of your points?
Yeah, you did.
Great, thank you.
Thank you. Commissioner Newman?
I have a couple tiny little sort of almost typo-like comments, and then I have a bunch of more global comments. There's a reference in, I think it's 0060, that refers back to a previous rule, and I think refers back to the wrong section. It refers to 7, and I think it should be 8. Let's see if I can be more specific there.
Do you have the rules handy? Can you pull them up? I've been without a computer now for almost 2 days and I'm losing my mind. So sorry, I'm working from my phone. Yeah. Yeah.
Okay, I might not have just given you the right citation. Anyway, it's when there's a reference back to the exemptions that you've added, and I think you referred to the wrong.
The wrong
so
exemption?
We can just check that.
Yeah, we'll check that as quickly as we can.
And then the other picky thing is when you're describing the reductions, I had a little trouble following the paragraph where it says, okay, it's the difference between the initial allotment plus the highest municipal use during the 5-year period and the PTWs. So, and it seemed like that should be total allotments. It says, it's stated as a singular allotment.
Oh, okay.
I mean,
so one of the challenges is I was trying to put a math equation into words, and that's a challenge.
Right.
So the goal there is to take the total allotment, so the total volume of water allotted, add in municipal use, and then that is one number, and then subtract the PTW, and that gives you the volume of water that we have to reduce, and that's what we schedule for reduction.
And I thought that was what you were trying to say, and I think that allotment part sounds singular instead of.
And so you'd like to add an S, okay?
Yeah.
As soon as we get that up.
Total and S. Yeah.
We're in 60.
That make a difference.
With 7. Yeah.
Well,
for each kind of right.
Not the way they're describing.
The initial allotment will be.
But the way the rule reads, it's like take a single allotment.
Oh,
Yeah.
and this is 70 is what she's talking about right now, but we need to go look at that one too.
Right, compared to the PTW for that sub area.
Yeah. Versus.
I mean, I may have read it wrong, but I kept reading it over and over again thinking, this doesn't say to me what I think.
How does this change sound to you? So for the purpose of scheduling reductions, the total reduction in groundwater use for each subarea will be calculated as the difference between the subarea's total initial allotment plus the greatest single year quantity of municipal or quasi-municipal use within that subarea between the years 2020 and 2024 and the permissible total withdrawal.
That works.
Okay.
For me.
We've got that on the record. we can get that updated there.
Okay.
And then you had said it was rule 60, I believe.
Well, I thought it was 60, but when I looked it up just now, I don't think that's right.
We're gonna have to have them read out specifically the language.
Yeah.
I'll try to find it.
I I'm gonna stop sharing.
Maybe I can go to my global comments.
And
This is a really tough decision, and I mean, I haven't been on the commission very long. It's certainly the hardest thing so far since I've been here. I know you guys have faced some other tough things in the past few years. And I think it's important for people to understand where we're coming from and what's motivating whatever decision we make here. I think it's great that staff incorporated several of the key elements of the petition, the exempting the tribal rights, the municipal rights. Good changes, I believe, and because of the minimal amount of some of those rights, not something that's going to cause a huge problem. Removing Upper Blitzen seems to make sense. Sorting out what happens if you have POAs in two different sub areas, that was a good clarification. The rescission provision is a good response. And I know that Jason mentioned a few others, like the definition additions. And so I think it's really critical to know that we did in fact respond or be responsive to at least some key elements of that petition. The petition obviously has a lot more in it. And I just want to say a couple things about some of the things in the petition that I couldn't necessarily get behind. One of them was several times throughout the petition, there were almost commitments to state funding, or at least, there were several provisions that said OWRD will promote, fund, or will seek funding, will do this, that, or the other thing to buy out water rights, to do a number of different things. And I don't think that these rules are the right place for that. I think that we are committed to helping fund, whatever that means, to helping support funding for voluntary agreements, for well deepening for domestic wells, for helping with metering installation, all those kinds of things. I don't think we can commit the way the petition language committed to some of that up front. The other major thing, I guess, in the petition that caused me some heartburn is trying to essentially exempt the 3 sub areas that aren't in as bad shape. I mean, everybody recognizes that, but exempting them and saying, we're not even going to do anything until they hit a certain trigger point. And to me, that's just not going to solve our problem. It was too far down the line. It was going to allow too much more use. And I do appreciate that people feel huge economic anxiety about how this is all going to work. And it's going to take a while to start to feel some of those impacts, and adaptive management is going to help. Additional funding for all kinds of things will help also, but not taking a fairly aggressive, or at least an assertive action at this point is also going to hurt economically. I mean, that we heard a lot of testimony from people about how they want their kids to be able to take over their property, and that is that really resonates. At the same time, it's like, if the water's all gone in 30 years or 50 years, that's not going to happen. So I feel like we're in a really, really tough position, but we're trying to undo some mistakes of the past over almost an equal time period. It took us a few decades to get into really bad shape over there, and it's going to take a few decades to get out. Just a couple other things about the substantive, and if you want me to stop and come back with.
No, you're saying quite a few things that I'd like to say too, so
Okay.
keep going.
Okay. I mean, I don't want to go on too long, but these are all the things that have been boiling around in my mind the last few weeks as I've reviewed all this material. There's so many comments about you didn't listen to us, or there was not enough public participation, or not enough outreach. I feel like it's because maybe people were talking past each other a little bit, or that people were saying, you're not listening to me because I want you to, to do 15 sub areas, or I want you to exempt my area. And you're not, you're sort of proceeding along this path. Because if you look back, I mean, I looked at all the responses of Water Resource Department staff to the written and oral comments, and if like page 46 to 51 of the 119-page document that summarizes all the comments and gives Water Resources response, goes through all the participation elements, and Kelly did it again today. I mean, there are just things in there that just strike me as strange, like the counties and the cities saying, you didn't do any of the local government coordination. And there's like, we sent you letters, we met with you, we offered to meet with you. And so I feel like there's, I don't know, there's maybe some misfiring or misunderstanding or something, but I don't see that the department didn't do a massive engagement and public participation effort. And by the way, that just a side comment there, I really do appreciate the way staff groups, classifies, summarizes the comments, and then gives the response. That's really, really helpful because, you'd see 260 written comments, it's a little overwhelming. And the thing that I think we have to emphasize too is that there were a number of comments that said 30 years is too long. 50% of the wells is, reaching a target is too low. The PTWs are too high, low. I can't even think of what it is now, but because we're starting from a depleted place, and everybody recognizes this is not going to lead to recovery. It hopefully could lead to stability. So there were plenty of comments on the side of this doesn't go far enough, or it favors irrigated ag too much, or so on and so forth. So, we have to kind of land somewhere along that spectrum. The comments that we should be using the reasonably stable definition from the groundwater allocation rules, that doesn't apply here. I mean, this is a whole different thing. It's a critical groundwater area. And so trying to reach no further decline is, given where we have been already, seems to me like a reasonable goal. And I guess one of the last things that's really strong, that comes through so strongly in the comments, is don't do this to us, let us figure it out. And I hope that can happen, but sometimes you need a thumb on the scale, or I mean, why do we have habitat conservation plans under the Endangered Species Act? Because there are listings and recognition that things have gone badly for certain species. And so then you get the listing, and then people say, okay, let's figure out how we can manage within this framework. And I think that's what has to happen here. I want to see voluntary agreements. They can't all be the state buying out water rights. I mean, they have to be the people in the sub areas saying, hey, let's do a dry year option arrangement, or let's do, let's pool and do a rotation agreement or something like that. I mean, I hope, and I hope that the state can come up with some funding, looking at Mark back there, for, facilitating the development of those things. And as Tim said, we can do some modeling as well. I mean, I think that's a very exciting prospect, but and the promoting research for dryland crops and, I mean, there are lots of things that can happen, but it needs to start happening. And in order to start happening, I think we need more than a rule that says, go figure it out, folks in the basin. Like I said, there's going to be an economic impact either way. I noted Joe said this morning, and I think he's going to probably bring it up again, that, maybe there's a way to target some of our grant money for specific efforts in this area. Irrigation modernization, et cetera. Anyway, that, I guess the final comment I have there is that this is not the end by any means. This is a beginning of a next phase, but it feels, all the carve outs that are requested for the different areas of the disagreement with the lines drawn, the disagreement with treating it as a whole basin. I mean, I went back and read the geological studies. I'm not a geologist, so some of it was painful, but it's defensible. I mean, this is a single groundwater basin. And yes, there are different areas that recharge differently, that respond differently, but like these guys said again today, there's no barrier to flow, and you can already see flow going backwards in some areas because of the cones of the interference. So the PTWs, I think, are defensible and reasonable. The boundaries are defensible and reasonable, but this is so not the end. I mean, it is so much the beginning of trying to figure out how we can restore, not restore to historic levels, but restore stability to some of these aquifers. And the modeling that's been done and the reports that have been done, I empathize with people who come in and say, I don't agree, but none of us are, well, some of us are geologists, but most of us aren't. So I think we have to rely on the USGS and on our own staff geologists and the reports that have been done over so much time and all the engagement that's been done over so much time. And I think it's time for us to adopt the rules as now proposed with the modifications, and try to move forward. I mean, I'm sure we're going to get sued up the wazoo no matter what, either right out of the gate or after contested cases, but somebody could sue us for not doing anything about the problem too. So, okay, I will stop. Thank you.
Thank you, Commissioner Newman. I think I don't know what to say after that, because she really encompassed a lot of the things that I am thinking as well. Tim, did you want to respond?
I don't have a response
Did you
to
have-
that. I have a
want
response
something?
specifically to the modifications that Commissioner Newman
Please.
talked about. And so if I can really quickly share my screen, she's absolutely correct that we have an issue in our rule reference. So give me a second. I will share my screen. So excellent catch. That's what I appreciate most about attorneys, is they're very good at this. And so I've highlighted the rule reference in red there. It was 7. It should be 8. You're absolutely correct. I didn't get updated. The second piece was the Rule 70, Section 1. This is a proposed modification based on the language I said out loud. So again, I've highlighted in red where the rule language that's proposed in the attachment would change. So this is consider this a track changes version. So if that reads appropriately to you, it's great.
It does to me. It does to other people too.
Yeah, I think it clarifies. Yeah.
Okay.
Thank you.
Then we can come back to that when you get to an action.
Chairman, I ask just a quick process question about this. This is just for the kind of errors and corrections that were just made. Just from a process standpoint, can those be considered scrivener's errors that can be corrected after the fact, or do they actually have to come back if they were approved as incorrect? Do we need to do that during this kind of session, or is it it's a good question?
Yeah, Vice Chair Smitherman, Commissioner Mall, for the record, Jesse Ratcliffe. My recommendation would be that we go ahead and take care of these as folks are noticing them, and that the motion reflect those corrections. Once something is filed with the Secretary of State, it's usually the process is needing to, in many instances, it's needing to walk through the rulemaking process again. So
even for a scrivener's error, like
well,
that
I think so. We have some clarification language on the one, arguably maybe the other one on the scrivener's error, but since we've got a couple, and one of them is substantive enough, we should probably just kind of keep rolling here and make any additional corrections to get the thing filed correctly.
Makes sense. I was just thinking for down the road. Thank you.
Any other comments from commissioners?
I have some comments.
Go ahead, Commissioner Mo.
So I want to first go back to something that the question that Commissioner Wolf raised, and this question of, as Ivan described it, the prescriptive situation that we find ourselves in with our rulemaking process and just the rules themselves. And have we missed anything, which I think is a real fundamental question in terms of demonstrating process and demonstrating that we're in this together collectively for public trust. Because whether it's our grant making program, whether it's implementation of IWRS, we've brought up questions consistently in just about every meeting, calling for discretion, calling for, well, here's what the rules say. What can we do within those rules? And so the way I've looked at this as well, Woody, is that the rulemaking is at best sidebars that everyone can clearly see, and that our task is to, within those sidebars, make sure that there's enough room for voluntary agreements, for staff discretion, for local initiatives that come forward to be operable, so it sort of passes the gut check. And I think we err when we feel like the rules have to be black and white to the T. I think it's well beyond this issue. And so big picture, I align with Commissioner Newman that the rulemaking as it stands has done what I believe is adequate, and not only adequate, is admirable. Because one of the big things that we have in here, as Kelly pointed out, is, and I didn't realize it was the first time that the department has ever had an adaptive management framework written into the rules. That's fantastic. We should all be jumping up and down for that. Firm grasp of the obvious in many ways, but if we haven't done it before and it's there, the rules say we can adaptively manage. That's important, and we should feel relief and celebrate and be ready to work, because we know that if anything, we're going to get curveball after curveball on this, and we're going to need to adaptively manage. I take a lot of heart in that. So I'm there. I have a couple of specific, just small questions first, and then a couple more bigger comments. First, with the tribal exception, which I'm fully supportive of, I was surprised, however, to see that the monitoring and reporting was called out separately as also not required. And I assume that was just the assumption, again, because of tribal sovereignty, that we would never expect to require a tribe to do something like that. However, I certainly don't want to miss the opportunity. And could you just reassure us that we're in collaboration from a co-stewardship, co-management model, that the tribes are on board in terms of providing at least water use data? I know tribal sovereignty there's a great deal of reasonable concern for use of tribal records for culturally important properties and practices and things, but am I worrying about the wrong thing there? Are we going to be able to get the data that helps us?
Vice Chair Smitherman, Commissioner Mall, great question. You're getting into my other director talking points tomorrow already.
Okay.
But the Burns Paiute Tribe has sent us a draft MOA. They're interested in crafting a co-stewardship agreement with the Water Resources Department. So I very much expect them to be cooperative partners in monitoring on their tribal rights as others. But we have lots of discussions to continue forward there, and I'll provide a brief update tomorrow.
Thank you. That's great.
But good question. Thank you.
Thanks. Commissioner Newman's note about in the petition, the OWRD will, I do believe that we want to make a statement like that. We will be engaged in not only this community, but in other communities, because the implications of this immediately going to Klamath and other areas are huge. And we know that we've got a lot of work ahead of us. And I think that culturally continuing to move OWRD in the direction of not just being the regulator, but also the contributing participant in terms of acknowledging the legacy of what we've brought forward and how we can address that by steering financial and other resources towards progressive sorts of things is going to be really important that those statements are made. I agree 100%. It's not within the rules. That's not something that I think within the rules themselves. But again, after the size bars are established, being very clear that we have the commitment and also the flexibility and the adaptive management and the gumption to do it. And I guess there's a 4 or 5 different anecdotes just within the last few weeks. Woody in Corvallis, I was with, I can't remember who it was. He worked for TFT when you did your project with a web company years ago. And we were just talking about how such a difficult, politically charged sort of thing at the small local level that you chose to do has had such an immediate demonstrable impact on salmon coming into and spawning again in that area, and how the sort of energy it takes to, do you got it right? I don't know, we're going to give it a try. And I feel like that is one anecdote. Yesterday, I was in the town of Blue River, which is one of the communities that was essentially wiped out by the 2025 Labor Day fires. The entire 170,000 acre footprint, I think 460 people lost their homes and residences in the large valley. The entire community of Blue River was almost lost. 6 houses were opened yesterday with a ribbon cutting ceremony by the new Community Land Trust. It's a housing land trust up there. 6 houses that are supported in a way that makes them affordable, allows people to develop equity, come back into the community. I think all told, less than 50% of the housing that was available at the time has been reconstructed in the last 5 years. So very small, in some ways, incremental steps, but there's incremental steps and they're trying things. And that too just makes me feel like we're there in the basin. We need to now move and try some of these things and test those assumptions on whether we got it wrong or not. And then many of you know I spent much of November in Japan doing some work with wildlife human conflict there, but I was cognizant the entire time, like my in-laws, cousins are dairy farmers there. And so they're acquiring silage and feed and other things, some of it imported. And it was something that I talked about with producers when I visited the basin in August, how that market is changing. And therefore the market for the products that the basin is producing is changing and changing pretty rapidly. And so the adaptive management that individual operators and farmers and others are needing to do is something that we need to be cognizant of and be behind. So again, just these little anecdotes of, yeah, things are moving and they're moving quickly. And aside to that, remember in that last meeting, the economic consultant for the city of Hinds and Burns pointed out that the economic future that at least he is projecting is one of retirees coming to the community. That's a very different sort of future. And so again, let's not, back to Wendell Berry, let's not err on dithering right now. Let's get moving. Let's continue to commit ourselves to resolving these things in practical, difficult ways. But I feel like we're there as well, and look forward to that. The last piece of that then is, I don't feel like any of the things that either Commissioner Newman or I have said constitute a modification but I just wanted to make sure that you didn't feel that way either.
Agreed.
In the proposal.
Thank you, Commissioner Ball. Did that the opposite.
Turn it back on. Thank you, Commissioner Ball. Turned it right off. Okay, to not to belabor this, but to reiterate some of the comments that have already been made. I am pleased to see the collaborative work that went into incorporating some of the comments, many of the comments, I believe, in the petition. Yes, there are certain things that did not fully make it into the rules. However, I think that what I've seen is that you are using the best science available to you at the time, that you're willing and able and have committed to continuing to work with this community, regardless of what happens. This, like Commissioner Newman said, I don't see this as the end. I do see this as a beginning. We have to start somewhere. This is a very difficult decision. It's difficult for all of us, I know, because we truly value your comments and where you're coming from and your livelihoods. But again, to Commissioner Newman's point, if we don't do anything, if we don't start somewhere, this is just going to get worse. And then we're going to be in a much bigger issue, and trying to crawl back from that will be much more difficult than starting where we are right now. I do appreciate that we're going to work with the community on voluntary agreements, and whatever that process looks like, and we'll have more conversations about that. But again, that's a commitment to this community, that we recognize that people can take some of this into their own hands. It doesn't all have to be regulated, and that just knowing that there needs to be something done, that people can rise to that occasion and do whatever they can to help with this situation. I would also encourage the exempt users to look at how they're using water still. Look for ways to reduce. Continue to be a part of that basin and a part of that community, and understanding that their neighbors or people in other sectors of water use in that basin are going through what they're going through this process. And to just acknowledge and be aware of how water is being used within those exempt areas, I think will go a long way with the rest of the community and the rest of the folks in the basin. So I would just encourage them to continue to look for ways to reduce any type of waste as it relates to water use in municipalities and with the tribes. And also our exempt domestic wells. You know, there's ways for people to reduce their usage. So I think that it all can help. Let's see where else. You did talk about, I like how you also incorporated that those users that fall into both sub areas, because that could be really confusing of, well, which one do I belong to? And so you got to start with something. And so you're picking the basin that they have the most points in. And again, also reiterating that there are other tools. There could be funding legislature could work to provide funding for this basin. I don't know how that exactly would work, but we need to continue to look for ways to help this community. If it's funding,
or support or resources, however that looks. And I believe that staff is committed to doing that, and I know, and I believe that the rest of the commissioners, the whole commission body is dedicated and committed to that as well. So those are my comments. Does anyone have anything else? Commissioner Kihara?
There's the red light. This is tough. We are, in my time on the commission, we've basically gone through a pretty significant paradigm shift on how we allocate water and look at, what's the commission's role. I mean, past commissions, past rules, et cetera, has all been put water to beneficial use, and we've defined that as, whatever helps the humans, and business, and if there's water left in the stream, well, geez, that's just going off to the ocean and being wasted. To going, no, wait a minute. There's more than just people on this planet. There's more than just, springs are necessary. The bugs that live in the springs are necessary. Even mosquitoes are necessary because they provide food for other things. Even though I don't like mosquitoes. So it's what we're seeing now is a real paradigm shift on how we look at things, how we make rules, but we're also doing it not a way of coming down from on high and saying, thou shalt do X. It's like, we have a problem. This is what we need to try to achieve. How can we do that? In some cases, okay, let's make room for voluntary agreements. But if those don't work, what's the bottom line that we don't go past? So we actually fix the problem. You can't get yourself out of a hole by continuing to dig it deeper. And I think that's kind of where we have to look at where we're going with these rules. And I think the department has gone shouldn't say above and beyond, but they have done an incredible amount of work, an incredible amount of trying to find out what's necessary to communicate that to people within the basin, within the state. What do we need to do? How do we fix this? How can we put this into rules that will actually help start solving the problem? And understanding that solving the problem doesn't mean restoring it back to what it was in 1700. It's making sure that, okay, people are here, they need to grow food. We need to be able to use water to grow the food, et cetera. How do we keep that going so that continues on, but also that there's water in the springs, that my neighbor down the street doesn't have their well go dry and has to, truck in water so they can actually, drink, take a bath, etc. So I think we've come to a good place. Once we have rules, then we can start figuring out, okay, how do we deal with it? And I think that's where we're at right now. So I think we're good.
Thank you, Commissioner Kihara. Deep breaths. All right. Do I have a motion from any commissioners? Unless you have any more comment?
Vice Chair Smitherman, would it be helpful if I put something up on the screen to help with that?
I was just going to that. Yes.
So I've added a proposed motion. Please feel free to
Thank
do what you will with that. But then I have the two slides immediately following that that have the modifications. So the motion would be to adopt the rules with the following modifications to those two rules, and then we can go through those two modifications quickly as part of the motion.
So moved. You need me to repeat it? I can.
Yes, please.
That's it. I move to adopt the proposed Vision 512 rules as proposed in attachment 15, including the findings recommended by the department in support of adoption with the following modifications related to 690-512-00601 and 690-512-00701. And those are to replace the subparagraph in the middle of 0060 sub 1 with 690-512-00R18 instead of 7, which was in the draft. And to add language to 0070 sub 1 so that it reads as follows. For the purpose of scheduling reductions, total reduction in groundwater use for each sub area will be calculated as the difference between total initial allotment for the sub area plus the greatest single year quantity of municipal and quasi-municipal use between the years 2020 and 2024 within that same sub area and the permissible total withdrawal. That's the end of the motion.
Do we have a motion? Do I have a second?
I second.
Thank you, Commissioner Chiara. We'll take a vote. I'm going to start with Commissioner Mall,
Yes.
Commissioner Chiara,
Yes.
Commissioner Newman,
Yes.
Commissioner Lee,
Yes.
Commissioner Wolf,
Yes.
and I also vote yes. Motion passes. Thank you. Thank you for all of your work.
Thank you, commissioners.
Thank you.
So next up on the agenda is agenda item E. To discuss the Division 512 rulemaking petition.
Yeah, do you want me to stay put?
Vice Chair Smitherman, members of the commission, for the record, Ivan Gall, Director for the Water Resources Department. Here this afternoon to give a brief presentation on the Division 512 rulemaking petition. As you recall, that was a petition that was submitted to the department and the commission on September 12th, 2025, shortly after our last meeting there in Madras. Per ORS 183-390 there and OAR 137-001-00710, petitions submitted to commissions have to provide full rule language and also the facts or arguments showing the reasons for and effects of the proposed rule language there. The department has reviewed the rulemaking petition and concludes that the petition includes the required information there. If the petition meets that standard, the commission is charged with initiating a rulemaking or denying that petition within 90 days. Again, the department determined that the petition includes the required information, and so we began a process this fall with your assistance to move that process forward there. As you recall, we had a public hearing by the commission on October 3rd of this year, and we opened a public comment period between September 17th and October 7th to solicit public comments from folks here in Oregon.
Got a different presentation, don't we?
We sure do.
Let me see if I can get the right one. Sorry,
That's okay. One with like a new template moniker.
What was it, Cassie?
Okay.
Okay, sorry about that.
Go down to a box on the proposed rule. There we go.
And let me share screen.
2 days without a laptop has added up there.
It has, yeah. Sorry, little, my bad.
So wanted to provide a brief discussion, a little bit of kind of a comparison. The agency proposed rules, as you've just heard from the prior presentation, designated a single groundwater reservoir encompassed by one critical groundwater area that then was broken down into 7 sub-areas. And the proposed rules were looking at use reductions in 6 of those 7 sub-areas. Agency proposed rules also established a term, target water level trend. And this again is kind of where that policy nexus was at. That was a target of 0 decline for median water levels over a 6-year period, and proposed 30 years to achieve that long-term stabilization of the resource there. The petition language alternatively came in with 5 critical groundwater areas, each its own groundwater reservoir, and proposed reductions or curtailment in 2 of those 5 critical areas, and then an approach to take on voluntary reductions in the other 3 critical areas with an eventual regulatory backstop there. Our technical team used the petition proposal to do a model simulation. Those results were provided to the commission. And the petition's proposal definitely slowed the decline of the groundwater levels, but it did not result in the long-term stabilization of that rate of groundwater level decline there. After 30 years, the petition's proposal had a median rate of decline of less than 1/10 of a foot per year. 90% of the wells were still declining or slowly declining there. And then subsequent water levels range between 2.9 and 25 feet lower than the agency proposal would have resulted in. Those lower water levels have the resultant impacts on domestic wells, spring and stream discharge, and natural evapotranspiration there. The department's proposal, which again culminated after 2 years of process and the many RAC meetings and engagement in the basin there, strikes a balance between managing groundwater use in the basin for sustainability in future generations and the economic interests of those using that groundwater resource there. Again, really all of this is around the fact that we had the declining groundwater levels. We have to get to reductions in use in order to stabilize those groundwater levels there. And the policy decisions around defining that target water level trend and then the timing and amount of groundwater use reductions to meet the target water level trends are really important. And the agency put forth our preferred alternative in the prior discussion and in the proposed rules there. But I think it just bears repeating that there's this spectrum of management options that could have been selected in the basin, all of which result in different endpoints out there. But we do, as we talk about supporting the voluntary agreements, we do have a very valuable tool in the model simulations to help us answer these what-if questions and look at additional scenarios there. Options for the commission to consider. Number 1 would be to initiate rulemaking based on the rule language in the petition. Or number 2 would be to deny the petition. It's the director's recommendation that the commission select option 2, which is to deny the proposed petition that came in September 12th of this year. And so I'm happy to take questions from the commission on this topic.
Do we have any questions, commissioners, for Director Gall?
I have a comment.
Commissioner Newman?
Feels like we're doing this backwards.
Definitely.
I think that we should deny the petition because I think we just did what we determined was a better pathway going forward.
Vice Chair Smitherman and Commissioner Newman, I hear your comment there, and we wrestled with the order of operations today internally. We settled on asking the commission to adopt the department's proposal first and then addressing the petition second. It certainly could have been mixed up different ways. This is probably, I think, only the second or third time in my career the agency's been petitioned and the commission has been petitioned. So it's not something we deal with frequently.
Any other comments, or we can entertain a motion?
I move that we deny the petition.
I'll second that. We'll go ahead and take a vote. Commissioner Mall,
Yes.
Commissioner Chiara,
Yes.
Commissioner Newman,
Yes.
Commissioner Lee,
Yes.
and Commissioner Wolf.
Yes.
And I also vote yes to deny the petition. Thank you.
Thank you, Vice Chair, members of the commission.
So it looks like we're a little ahead of schedule. Does anyone need a quick break before we go to public comment? Okay, I hear sure. That sounds like a plan. We'll take a 15-minute break and we'll be back for public comment.
Someone's got to get across the mountain tonight.
All right, we're going to resume the meeting. We're going to item F, public comments. And I'm going to start, we have a couple people who are virtual who want to also give public comment, but I'd like to start with the people in the room. I heard maybe they might need some travel time. So I'd like to start with Representative Owens. You're going to pass it this time. Okay, I will move on to Rob Frank.
Want us to come up here?
Please. Yes, thank you. Would you like us to come back to you, Representative Owens, or?
Fine.
Okay, well, I'll check with you in a minute.
Thanks, commissioners. As most of you know, I'm Rob Frank, Harney County Commissioner. I was elected to represent the entirety of Harney County, the majority and the minority. And I am very aware that when it comes to water issues, there are some differing views in my county. But I try to temper every action, every comment I make with what I believe is in the best interest for the future of my county. I think that we could all agree that the function of the state of Oregon is to serve the people. And unfortunately, this process kind of devolved into a pissing match between the people of Harney County and state bureaucracy, with the Water Resource Commission caught in the middle. But I feel like the purpose of these commissions is to bridge that gap between the bureaucracy and the people. I feel like the petition amendment that the people of Harney County brought forward with a real strong unified voice to say this would better serve the people of Harney County and was given literally no thought today. We had the city, tribal, and county representative governments unanimously bring it forward. And we used the same data to draft that petition that was collected over the last decade of collaboration between the state and our community. So that was a little frustrating. I don't believe the entire basin had to be declared a critical groundwater area.
that dwarfs any other critical groundwater area in the state by orders of magnitude. And several times I've heard it said that the science shows it is one groundwater area. I reread the USGS report last night, and while it does say that it is it's hydraulically connected, it does not use that term one groundwater reservoir. And a groundwater reservoir is a standing or moving body of water. I think that it's a conflation of policy and science, and that's been a frustration all along. The difference when modeled between the petition and the proposed rule in the worst area was 0.09 feet a year decline after 30 years. That's a little over an inch, but the difference between the petition and the proposed rule could be as much as 5% of the total economy of Harney County. That's that many more families that can stay in business. And so that is a concern to me. To be candid, I find the attitude of nonchalance exhibited by the department in regards to litigation unacceptable, both as an Oregon taxpayer and as an elected representative of an entire community that is stuck in a nebulous cloud of uncertainty. Complacency about a drawn-out contested court case process recently stated at a GWAC meeting that it could take 7 or 8 years is unacceptable when we came forward with an amendment which would undoubtedly have lessened the need for people to legally defend themselves and their property. One other thing I did want to comment on is, for clarification, the joint letter that was sent by me this week was not public comment, but a governmental notice to indicate that coordination had not been reached. And if you read that, I feel like it is very clear. I just needed to clarify that. And I'm sorry we couldn't give you more time. I'm sorry we couldn't get it in prior to the public comment. But as you've seen, our communication has been pretty limited throughout this whole process. It's been the commission talking to the staff and the staff talking to the commission and never having a chance to question. I mean, we did have that one meeting where the petitioners were able to talk a little bit, but not really open communication. And so I do look forward to more collaboration in the future, as has been true to the history of Harney County's collaborative spirit. Thanks. Yeah, questions?
Go ahead, Commissioner Mo.
Thank you, Commissioner Frank, for making the drive, for continuing to engage. I'd love to hear from you. 3 things that you think we can do now going forward to support the effort framed in as it is, or even one. I mean, I know you were thinking about this daily. So is there 1 or up to 3 things that specifically you think we can do going forward to support, to help minimize the impacts of what you project to be that 5% gap, or, the losses? I mean, what's on your mind?
You're just the right guy to ask that, because if we're talking about moving forward with this rule as proposed in a single groundwater reservoir, the one thing I would say, and I'm glad you brought that up, because you mentioned earlier in the day and talked about finding ways to fund buyback. And Commissioner Newman also made a comment earlier about the state buying back water rights. Well, I mean, honestly, a 3rd grader would look at this problem and say the solution is for the state to buy back the water rights that they over allocated. And so I think for us trying to get creative about how to make that happen, I've already been working with OWEB because they have that water rights acquisition program. But oddly, we worked with them and they said, well, it doesn't really fit because it's for surface water, not groundwater, and we can't tie groundwater and surface water together. Yet the Water Resource Department, when you read the staff report, does talk about the implications between groundwater and stream runoff and spring runoff and natural evapotranspiration. So I am hopeful. You guys talked a lot about grant money today. I mean, just doing some quick, dumb cowboy math, for the amount that they want to curtail back at the end of 30 years, going off the numbers they used in Nevada when they did their pilot project, $41 million would buy those rights back. And people might say, well, yeah, but what is that? That still doesn't fix your agriculturally based community. Now they don't have groundwater to irrigate with, but it gives them the flexibility and the latitude, the breathing room to pivot to dry land or who knows what else, instead of just watching them have to pack up their boxes and pull their kids out of school and move away. So thanks for your question. That's what I'd like to see. And we will continue to work towards that as well.
We share a love of music. I don't know if you've heard the recent quote from Jeff Tweedy of Wilco. He says, creativity eats darkness.
Yeah, there might be a lot of truth to that, actually. Yeah. Other questions?
Commissioner questions?
I think so. Thank you.
Well,
Okay, thank you, Commissioner
thanks.
Frank. Thanks for being here. Okay, next we have Mario Petrelli.
Everyone, good to see you again. Jerry, if you're out there, I love your work. For the record, Mario Petrilli, Burns, Oregon. I am an engineer, and engineers are trained to tackle problems a bit differently than most folks. I also am a surface water guy. To understand the groundwater problem, what I did was a statistical analysis of hydrostatic levels over a long period of time. Basically what Mr. Groden and the team did, 4 or 5 years ago? Except I have more data, many more wells. Don't use criteria and use means instead of medians. The numbers are the numbers. And some of my numbers are larger than the department's. For example, Weaver Springs. Oh my God. 37.5-inch decline every year. We've got to do something about this. Dog Mountain, adjacent to Weaver Springs. 22.3 inches decline every year. What's interesting is you look at the 12 area model that the water department used 4 years ago, or the 14 area model that I use. Dog Mountain has either the second or third highest gross and net consumption. Yet it has within the 7 sub area the second lowest PTW reductions. Why? I don't know about how that would work. Rattlesnake. We got to do something about this. 19.4 inches every year. The department missed this. They missed this spot. There were no observation wells. This is why my numbers are worse than the department's. Buchanan. In the northeast Crane area. This also we have to do something about. It's over 12.6 inches a year. Crane. 10.6 inches a year. What's interesting is there are 2 areas in Crane that have substantial oscillations, seasonal oscillations, and somewhat dramatic declines in the hydrostatic levels. But there are 2 areas where the hydrostatics are level or even increasing. The department missed 2 more spots, no observation wells. Lawn. Almost a third of the total mean decrease is from a department deep well. I believe it was at 220 feet. Lawn is not receiving intermediate and ground migration from. Go ahead, shout it out if you know the answer. It's okay. From Rattlesnake and Buchanan. Otherwise, the numbers would look more like this. Princeton, 3.4 inches a year. The study area includes Virginia Valley and some of Anderson Valley, where there is substantial irrigation. It is within the USGS Malheur Lake HUC, but is outside of the Rule 512 SWMPA. The levels beyond on both sides of the boundaries are about the same. I don't know why Virginia Valley wasn't included. I guess the department had some confusion on where the true Malheur gap is. Sylvies, where most of us live, 2.8 inches a year. Now I know you've seen more dramatic reductions over shorter periods of time than this. Voltage, which is on the south side of Malheur Lake, 3.9 inches per year. Warm Springs, where the springs, most of our thermal and larger springs are at, 2.3 inches per year. Sagehand Valley, which is a subset of the Silvies Basin area, just over 2 inches a year. This is not to say that there are not wells of interest in the area. French Glen. I use the hydrological boundaries rather than the administrative boundaries of Upper and Lower Blitzen. 2-inch decline a year. This is not to say that there are not wells there of interest. Silver Creek. We're talking millimeters decline over many, many years. I'll beat the Diamond. Diamond, which is in the Lower Blitzen area, actually has an increase of over 1/2 inch a year. What is difficult for us to understand is you're talking to the Silver Creek families and you're saying you're going to have to endure the initial beneficial use and the 2.5 acre feet limitations. The question we have is, why? What were you thinking? Collective socialism? It takes a village to raise a child, so everyone must participate in the solution to correct a problem that someone else has created? I'm sorry, but when I do look at the numbers, I have to say the department overthought the process. They did it backwards. I will say this, the department staff did an excellent job. They did the best they could with what they had. But I've seen this movie before, and maybe you've seen it too. About 40 years ago, it was called The Spotted Owl. That was political science done with the best science available. I lived through that. I don't intend to live through that again. Mr. Gall, I hate to say this, but you're our barred owl. And thank you for your time. I'll see you in court.
Thank you for your comments. Next up, we have Larissa Singhos.
Hi. Thank you, Chair and members of the commission. My name is Larissa Singhos. I'm a farmer and rancher in Riley, Oregon. I'm in the Silver Creek sub area. I had a whole bunch to write, and after what went down today, I don't think that it is what I should say. And so I'm going to wing it, which I'm terrible at. So please bear with me. I'm going to use some of it, but I'm going to start off with, yeah, we've seen a lot of science and we've read a lot of reports and we've done a lot of research, and the department has done a good job of bringing that together and giving it to us. I personally have a problem with is what you were presented with and what you weren't presented with, how it was presented to you. And you can take a thing and how it's presented or how you look at it changes it. So I'm just going to talk about a few examples if I can. I believe if the community was allowed to present in front of you guys for even half the amount of time that the department got to, I believe that you'd have a completely different perspective. I think that we could have had exchanges and had questions and seen what we thought and why. Anything that I've ever talked about or any data that I've used is the department's data. So it's just all out there. So I'd like to give you an example of one of these. Example of this is how the PTWs are actually going to play out in reality. In the Silver Creek sub area, we're being given a PTW of 15,200 acre feet
and is going to be allocated at 2.5 acre feet, which would equal 6,080 acres of irrigated land. The department told you that that was a 28% reduction. The Silver Creek sub area irrigates approximately 11,000 acres. The reduction would dry up and destroy 5,000 acres, which is actually 45% reduction, not 28. The current conditions, in my opinion, don't justify a 28% reduction. So how can a 45% reduction be considered acceptable? We, as Mario presented, we're barely declining, we're very minimal. And there's other impacts that they're saying, well, since we're just gonna take the bad areas and we're gonna throw everybody together because we all impact each other. And so here's another example I would like to present that I feel is a little misleading information. And there's many more examples. Some of the examples are how the department has overstated the environmental impacts with assumptions, not facts. There are reports and data that support this. What if I showed you that the lowest historical measurement of the Warm Springs Valley Springs was not in recent times, but before groundwater development occurred in the basin? The historical low was in fact measured in 1916, 17, 18, and 1931. The USGS spring measurement taken in 2017 was not the historical low. It was about 100 years earlier and well before groundwater development. This is from reports that was done off of the USGS numbers. These are their numbers. It's just in a little different form than you've probably seen them. It's much more user-friendly. But I've looked at the USGS, the Barnett report. I've looked at Piper report, and there's others. There's other things that could be explored about the springs because they're using the springs to drive their agenda for certain areas. Is there impacts? Show me the data. There could be. And I'm not saying that we need to give up springs to keep going. I'm saying we need to know the truth and we need to know the facts. We don't take 45% from an area because that's what they're using against us. We're 30 some miles away. Weaver Springs is less than 10. And when I've asked about Weaver Springs, not the big impact on the springs. We are supposedly. If there is an impact, I don't see it, but they want you to believe it so they can push the agenda with partners and stuff. I'd also I sent in some written comments. You can read a little bit further about this. I also see that we are concerned about the procedural integrity of the rulemaking. A public record request shows that public policy concepts emerged after undisclosed meetings between a RAC member / GWAC chair and department staff. This information was not shared or disclosed to the RAC, preventing other RAC members from evaluating, deliberating on, or advising the department about these concepts. The absence of transparency undermines both the RAC and the GWAC's ability to fulfill their advisory roles, and it raises serious questions about whether the rulemaking process met the standards of fairness, transparency, and inclusive deliberation required under the Oregon Administrative Procedure Act and ORS 536.090. These are just a few of the things that concern us. And like I said, it's not the question of the data, it's the question of the presentation of the data. And I don't think that taking an area with inches of decline a year and taking 45% of our irrigated ground away, because if we want to talk personal, that's everything I've worked for. Over inches. All we want is a chance. And I don't think that we're going to get it with the department through voluntary agreements. I think they're willing to work and say they are, but they won't. They keep saying they have to meet their same standards. Their same standards is 0. Your water has to drop 0 or you do not meet the standards. You cannot accurately measure 0. You stick your thing down there, sorry, I'm nervous. You stick your measurement down there, it's not an accuracy of inches, but we're being held to 0. And they're going to tell us that our voluntary agreements are not going to be good enough because we don't reach 0. When if we have no changes, I mean, our envelope, if you understand that envelope adaptive thing, we have like, I think it's a foot, 1.7 maybe feet that we have to stay in to even meet their goal, because our things are like this. Other places can drop this much. We're dropping this. In our recharge area, we're only going to be allowed to use 43% of the recharge. Other areas are going to be able to use 77% of the recharge, and some areas are only going to be allowed to use 18% of their recharge. So we're not even asking to not leave some in for the environment. We need a healthy environment. We're farmers, we're ranchers. We need a healthy environment. We don't want destruction, but we're asking for a fair chance to survive. That's all we want. I need it to be facts, not just because somebody behind the scenes wants to save some unknown thing and they're going to put it all on us when it's not even factual. That's all I want. I just want to farm and do the right thing, because we can do both. We have to do both because everybody in this room needs food. So the problem is, if we set these standards so low, for example, my area, you can't drop an inch. How are you going to save agriculture in Oregon? You won't, because that standard is not doable. We can do better. We can always do better. But we can't if we're financially destroyed. You can't do the right thing when you're barely just trying to make ends meet, or if you can't even make ends meet. That's all I ask for, is a chance. 28% is not 28%, it's 45%. And that's just in my area. So what are the other areas? I can't do the calculations for everybody. But I just ask you to consider that. Thank you. And I'll take questions if anybody had questions.
Thank you, Larissa. Does anyone have any questions? Commissioner Mall?
What do you, I don't want to jump in if others are. Nobody else has a question?
No, go ahead.
Thank you, Larissa. We don't have quite the relationship that Commissioner Frank and I do, so I hope this doesn't come across as disrespectful, but I would like to ask you the same question. Preface it by saying, when we did first meet in August and you described yourself as uncomfortable in these sorts of situations, you may not see the difference between then and now, but your kind of testimony and the poise with which you give it and the depth of the research that you give does tremendous justice to this project, to this process. So I want to thank you for that. But if you would, given the decision that the commission made today, all of the background that you've given us and the impact that you'll acknowledge and feel directly, you've expressed some concern that the voluntary agreements may not be as workable as we hope they are.
Yeah.
Is there one thing, two things, three things that you would recommend we begin working on today together within this context that can help address some of these concerns?
Well, first of all, I think we need to restart all over with the actual PTWs. The PTWs numbers for each area was given for a basin wide. It was done a basin wide average of 2.16, I believe. I don't have, and then everybody was assigned that for every irrigated acre. Well, people that were using more than that, or acres, I ask at times, I'm like, well, how many acres did you figure for each sub area? Well, we didn't break it down that way. So they didn't even double check. Did we get all the acres? Did we get all the information? I mean, how do they project 28% reduction, but it actually calculates out to 45? I mean, to me, 28 is already too much for our area, and some of the other areas that are dropping similar to ours, some of them are like 43% reduction. They're probably going to lose 80% because of the calculations. And so we just need to understand what you're really signing on the line for us for. I don't think you've ever heard anybody say that we should not, that there's not problems. We understand. I think we're realistic. We understand that there's areas, but the problem is an area over here does not equate to a problem over here. But we've been lumped together, and we believed that this area that we know is critical and it has to have something done. We know that. But it does not equate to everybody. And so I think we need to start there and like, are we really doing what you think, or are we actually doing way more damage to the water, to our economy? I think we start there. And as far as like helping with voluntary agreements, I don't know. I mean, we're working on them. I mean, we have to do a whole legal thing on it. I mean, we're financially funding the legal, we're finding technical help. And we're going to go and we can sit here for hours and spend thousands of dollars. And then the department can say, nope, it doesn't match my model. No, it's not going to get us to 0. It's only going to get us to 0.1. And they keep saying, well, 0.1's not good enough. I think we need to be realistic. I don't know. It's hard for me to say exactly. Yeah. Thank you. Thank you for the question.
Thank you.
All right, thank you.
Thank you, Larissa. Appreciate your comments. I believe we have one more online, and that is, oh, Mark, are you wanting to come on? All right.
I don't want to miss Jill's question.
It's a good question.
Start with my question.
Ask it. Vice Chair Smithman and members of the commission, for the record, Mark Goins. Tough day. You guys articulated that. We're feeling it. You've heard that from our community. So a question was asked during deliberation, what might have we heard if public comment had been opened again? What might I have told you, or what I would have told you, is once a petition was filed, we knew it wasn't 100% correct. It was put out there to once again try to have a conversation with our community on what could be different alternatives. We were given the opportunity to have one meeting with the department, and I was told a week prior to that meeting that modeling would have been done on the petition. So we could go over the modeling, we could talk about next steps. Public comment ended about that time. We had the meeting. We were told the meeting model's not done. We can't tell you what it is. That meeting was probably one of the toughest meetings that I've been to with the director's office. They were very frustrated, maybe rightfully so, because the petition that came through, public comment was opened back up. It was going to be a lot more work for the staff. During that period of time, a couple of us had a conversation with the governor's office. And what we were told is you'll be given an opportunity to submit different scenarios to see if we could come up to a middle ground. And we were told, or I was told, I won't say the other person, that during this meeting, you guys would be given a NEPA process, alternative A, B, C, D, E, which you could choose from. That was a commitment that was made. And you saw potentially part of that Saturday when the staff report was revised. And I'll talk specifically about one of those model runs. The model run that increased the voluntary reduction to 15% was only part of the model run that we had asked for. We asked for 10% accelerated, I forget exact date, and then a potential 5% put on the back end. But then we also asked for an increase in Weaver Springs. We also asked for the same quantitative reduction in Northeast Crane that was put into the department's preferred alternative. Because when we changed that boundary, we weren't asking for less reduction. That was a trade-off that we had made with our community. And so we were asked, I ask now, I mean, why wasn't that model run done exactly, or even to the intent of what we asked for? I don't know. But those are things you might have heard if we had the opportunity for a conversation to occur in the last 60 days, as we didn't. And maybe then you would have been given an opportunity to make a decision on 0.1 inch, but maybe even less. And if we would have got through that steps, we would have saved a lot of the litigation that's coming forward. We would have. Were we going to eliminate all the litigation? We're not. So those are the things you might have heard if we had an opportunity for even commissioners to be able to reach out to a broad scope of people and say, hey, I'm hearing this. Can you tell me something? But that's beside the point now. So Joe, you ask a question, or Commissioner Mole, you ask a question. What can we do now? So now you have a regulatory backstop in all the sub areas, which the petition didn't have. And maybe through one of those model runs, we would have changed that. So now you have the regulatory backstop. So what does the critical groundwater designation allow the department to do now? They don't have to do anything. They don't. They can choose to take a contested case and start the regulatory process in all of them or a portion of them. So you can make a recommendation to start a contested case in a subset of the sub areas. Northeast Crane, Weaver Springs, whatever you might choose. And then you might say in Silver Creek, Sylvies, and Lower Don and Blitzen, we're going to let this community, those landowners, focus with you guys on volunteer agreements. Instead of spending the money litigating through the contested case process, which is going to occur, we're going to say no. We're going to make a commitment to those people in that committee that we're going to instruct the department not to start the contested case till 2034 if you've entered a volunteer agreement by 2028. What would that change to the modeling? Well, we know the regulatory recommendations that would go through a contested case in Northeast Crane and Weaver Springs are more than what the petition does. So if we add in more reductions in those areas, maybe you get to 0.05 feet of decline. Maybe you get to that far. And if you don't, in 2034, you start the contested case process. But what you might find is our community might come together and say, hey, it's not doing the trajectory that we actually want. Maybe we'll increase those volunteer agreements by another %, another 5%. Maybe you want to give me hope that you would instruct the department to slow down on some of these sub areas. Let's do the collaborative process. Let's see how accurate the model is. And in those 3 areas, guys and gals, I mean, even if we're wrong, we're talking, till 2034, maybe we lose another couple of feet, but you probably won't, because you're probably actually going to get reductions a hell of a lot sooner. Excuse me. Why did the department pick 2034 in order to say that if they're not on trend, then we reduce 70%? The contested case is not going to be done until 2034. It's not. So we could sit here and figure out how to continue to argue. Bad statement. We could sit here and try to figure out how we can limit potential arguments and litigation and going forward, or we don't. So Joe, that's what I'd recommend. We figure out how to do that. We figure out the funding for the CREP programs because we're out of money for the CREP program. Yeah. Sorry.
Just to clarify, because what I'm hearing, and maybe it's selective hearing, is that with okay, I'm getting there, brother. What I'm hearing is that within the structure that's been created by the backstop, as you described it, that's doable, is what I'm hearing. That you see within the sidebars we have with the rules that we agreed to, that there are mechanisms to address some of these concerns and sort of test drive the model and see how we do is what I'm hearing. And in that, what I heard you say is there is a willingness already to consider a deep set of voluntary agreements in some areas that are arguably most impactful on the entire basin as it is modeled, that would be smart for us to collectively look at and do some things that we can do this. Did I hear that correctly?
I think so, Joe, just so, I mean, go through the regulatory process in the worst areas.
Mhm.
I think you'll actually probably see less litigation in those areas because most of the members have identified there's a problem.
Yeah. Okay.
Hold off on the others. But unless, as Larissa started to talk about, we have a realistic expectation of what a volunteer agreement needs to be, it'll fail. If we got to come in there, we're going to match the regulatory reductions that the department has set in a voluntary agreement, we're going to litigate. If you allow us that extra 6 years to work with you on proposing a 10% reduction in those areas or whatever they came forward, and you say, no, we're going to give this subset a chance to have the empirical evidence to see what the result is. Maybe we're right. Maybe we're wrong.
Yeah.
But
okay. Specifically, you and I talked a while ago about the change that will happen when Representative Helm leaves and with the Water Caucus. And at the conference I was at last week in Corvallis, there was a statement made by somebody who'd been in the land use world for 50 years, since the beginning of Senate Bill 100. And the statement was that the current legislature, because of its two factors, which was described this morning, the sort of the polarized nature of many of the conversations, as well as sort of the urban bias of just the lived experience of most of the legislators, makes it one of the least natural resource oriented legislators since Senate Bill 100 was passed. And earlier, someone remarked on, Harmony actually described, Harmony's still here, how important it is that the information going to legislators be what's the word? Consistent, but also digestible, I guess is what she was saying. What can we do as a department, as a commission to help with that? Because based on my experience, I find the same thing, that the complexities, natural resource issues, longstanding natural resource issues, is kind of lost in many legislative discussions because they're overwhelmed by some of the more urban discussions where people are just more familiar with some of those equally urgent issues.
I'll have to give that some thought, Joe. I mean, so much of volume of information comes to you as a legislator. I have a false tooth. I'm trying to learn how to talk with it. I'm not drunk. That most people pick a specialty. Ken and I have happened to pick natural resource and water. So how do we educate those that is not top of mind or top of the community? You're not done seeing me, so I'll come back up again in March and we'll have that discussion. Yeah. What do you guys' hand up by chance?
Commissioner Wolf?
Yeah, Rep. Owens, I was just wondering, relative to the proposed or the now rules, what kind of a glide path do you see that we can try to implement moving forward to minimize, I was going to say economic damage, but let's just face it, bankruptcies to irrigated agricultural interests in your basin? How much different? Because originally the curtailment was front loaded to try to reach stability sooner. What do you think is a reasonable economic time frame to minimize that, and can it be done within the rules we just adopted?
So So I will say that I do appreciate the phase-in period of 30 years. I think as Kathy might have said, or somebody, Julie, that, I mean, that's how long it probably took us to get into this problem. So we are working that. So I think that is good. So what do you, I mean, I'd have to just go back to what I said is, let's focus on these areas that if it wasn't deemed one groundwater reservoir, probably wouldn't even be in the critical groundwater designation, and allow them to have a conversation with you guys and gals on what is an acceptable rate of reduction in a voluntary agreement. And I think you'll find that they'll come through with something, Woody, that would hopefully stabilize groundwater levels, you know, within a dynamic equilibrium instead of durably stable. That could be a policy determination that you guys could accept and minimize economics. I'm not being very clear, Woody, except repeating what I just said. So, I mean, we can even ask the department to run the model on what would be with the current regulation in Weaver Springs, Dog Mountain, and Northeast Crane, and you did a voluntary agreement of 10% by 2028. What would it look like? And maybe we could start to learn there. But I mean, it just, I'll say what Larissa said again, durably stable at 0 is tough. Especially if you had talked to Zach, TNC, he gave a definition of dynamic equilibrium that could actually take in the weather events. And it varies almost a half a foot. I mean, durably stable is a recovery. That's a policy decision too. But I think there's some room there. Cool, thanks.
Thank you, Representative Owens. Now we have one more comment, public comment request from Christopher Hall. Or maybe more.
Good afternoon. Can you hear me?
Yes, we can hear you.
Vice Chair Smitherman and Commissioners, thank you very much for this opportunity to provide public comments. My name is Christopher Hall, and I'm with Water League. Full stop, we are grateful to Oregon Water Resources Department for their commitment to hold water in trust on behalf of the public, and we greatly appreciate the Water Resources Commission's efforts today in this very difficult situation. We accept that OWRD departed from its initial plans and conceded at numerous stages to appeals by irrigators over the course of the Division 512 rulemaking process. The late changes associated with the petition comment being the most recent. The end result is a very lenient outcome that does not recover water levels, but instead stabilizes them after what will be a near 70-year decline that started back in 1990 when the basin first fell out of balance and the deficit between recharge and discharge emerged. Groundwater declines have been engineered by these rules to stabilize over the next 30 years through 2058, which is a considerable glide path given that the current deficit is 110,000 acre-feet per year, roughly equivalent to the city of Portland's entire annual consumptive water use. Despite these rather extraordinary concessions, Water League has and continues to strongly support the efforts by OWRD to manage water use in the Harney Basin. The basin is the site of a tragedy of the commons, where every 5 to 9 gallons pumped equals a penny, and water miners, a formal term that has been used by the USGS, are powerless to stop making financial withdrawals from the groundwater reserves. The USGS and OWRD peer-reviewed groundwater study proclaims that, quote, most groundwater pumped from lowland wells is ancient and not being replenished at meaningful human timescales, end quote. while the emplacement of groundwater took thousands of years to collect and reach ecological balance, the severe impairment to the water sources in the Harney Basin took only a few decades to occur and will now last for generations to come. We note that posterity has not had a sufficient voice on this matter. This unfortunate circumstance is made worse by the revisionist history that claims and attempts to put all blame onto the OWRD for, and I quote, giving out water rights like Halloween candy. This is an unjustified accusation that ignores the extensive regulatory capture over several decades when pressure to permit subprime water right applications occurred. To minimize the harm from these deficient applications, OWRD set decline conditions on the water rights as a fail-safe against excessive declines in groundwater. These measures were necessary precisely because staff hydrologists had concluded that water availability for many of these water right applications could not be determined or assured. Across the board resistance to comply with these decline conditions in the present is reminiscent of the past. Surely it did take two to tango. The severe hydrologic problems in the Harney Basin stem from an improper consensus that both the state and the regulated water users uncritically accepted for decades. Today, however, the Division 512 rules represent a partial departure from that convention, and we applaud the state for that. While the Division 512 rules will ensconce measurable harm to water sources for generations to come, these rules will prevent the worst destruction that had been underway, and for that, we are deeply, deeply grateful. Thank you very, very much for your time. Have a nice day.
Thank you, Christopher Hall. Any questions or comments from commissioners? Okay. All right, that will conclude our public comment period, and we are ahead of schedule for today. So we're planning to pull a couple of items from tomorrow's agenda into today. And up next, we are going to go with agenda item J, and we're going to talk about budget and legislative updates. Yeah, yes, I think we can take a 5-minute break. There will be plenty of time. Thank you. 5-minute break. All right. We're going to resume the meeting, and we do have some more time today, so we are moving to an agenda item from tomorrow's scheduled agenda. We're going to go ahead and discuss today item J, the budget and legislative update. And I believe we have Bryn Hudson and Lisa Snyder online to give us a presentation, and also Raquel is here as well. So go ahead when you're ready.
Good afternoon. Can everyone hear me all right?
Yes, we can hear you.
Okay, perfect. All right, let me get my screen shared. All right, it's been a while since I've done this remote. Can everyone see this? Perfect. Okay. All right, Vice Chair Smitherman, members of the commission, hello. For the record, my name is Bryn Hudson. I am the legislative coordinator for the Water Resources Department. I'll kick things over to Lisa to introduce herself.
Good afternoon, Lisa Snyder. I am the ASD Administrator, Administrative Services Division Administrator here for the department with Bryn.
Thanks, Lisa. We've got to work on that name. So thank you all for being flexible in the agenda. I'm sorry I can't be there with you in person, but we'll go ahead and get started. So what's on the agenda for our discussion today? We're going to talk briefly on some developments from the November 2025 Legislative Days interim committee hearings. We'll talk about the preparation that we are doing for the 2026 legislative session. We'll do a really brief overview of the legislative and budget development process. I know it's been a while since we've talked about what that general process looks like, and we've got some new commissioners as well. So we'll do a little bit of legislative 101. And then we'll finish up with a brief overview of where we are at currently in developing items for the 2027 legislative session. So 2025 legislative days in November was a big topic of discussion around budget. So due to lower than anticipated state revenues, as well as reductions to funding at the federal level, which I will note is what current biennial budgets are based off of. So 25-27 biennial budgets are based off of those factors. Agencies were directed by the Legislative Fiscal Office to provide a 5% reductions options list for the current biennium for consideration for the 2026 session. So those targets and what funding pots were applicable to each agency looked a little different depending on the budget layout for every agency, because this was an enterprise-wide request. This wasn't just WRD. But our targets were specifically for general fund and other fund. So we were tasked with coming up with about $5 million in options for general fund and about $1 million in options for other funds. I'll go over at just a really high level the general approach that we use to develop these options. And first and foremost, our top priority when we were doing this work that we identified was delivering our core services through our existing programs to Oregonians. So as such, our most valuable resources in carrying out that objective is our staff. And so one of the lenses that we looked at was doing our best to preserve currently filled positions. Other items that we looked at were really around tightening up spending on services and supplies, which is just kind of a fancy term to say staff travel, career development and training, field equipment and supplies, office expenditures, stuff like that. We also looked at reducing spending from discretionary funds. So think grant programs, contracting dollars and resources for public information, outreach, public engagement, facilitation, surface and groundwater data collection and analysis, things like that. So not staff associated with that, but discretionary funding associated with that. And then we also consider reductions for direct appropriations for specific water projects, as those were included in the overall pot of money that we were considering options to pull from. I will note that in some instances where we needed to reach that 5% bar, there were a few instances where there were staff identified in several divisions on that list. But again, I do really want to drive home that these are options for consideration in 2026. No decisions have been made. The legislature will be the ultimate decision maker on this. So there's a lot of unknown at this point in time, and we will be sure to follow back up with you all if there are any adjustments that are made on to WRD's current biennial budget. So we will be absolutely sure to report back. But again, these are going to be short session decisions. So there's still a whole lot up in the air right now. So with that, let's turn our attention to the 2026 short session. So short session is set to take place February 2nd through March 9th. And as the name suggests, short session is a little different than our long legislative sessions. Largely in relation to the time. So you'll see this is only about a 5-week session opposed to the 6-week session 6-month session that we do in odd numbered years. Even numbered years, we're doing 5-week sessions. Apart from timelines, short sessions also have bill limitations. So we're often tracking far fewer bills, but because timelines are more condensed, we have new fun hoops to jump through with accelerated timelines. So it still moves really quick, and it's still, high pace and workloads are still high, but we're not tracking 800, 900 bills like we normally are. Typically, the legislature during short sessions are considering budget adjustments, as I alluded to, and policy bills. So when we do long sessions, that's when the legislature is building biennial budgets. Typically, in the short session, they're making tweaks and doing adjustments and not building budgets from scratch. So while we don't have a full slate yet of topics that we know are going to be up for discussion, we do know that there may be some topics going on that may be up for discussion around technical fixes for the water right modernization bills that passed back in 2025. So there may be some conversations around technical fixes there. WRD, so we've also identified a technical issue with how we define state engineer and how the current program is structured that may also be a topic of discussion. And we also know that, or we anticipate that conversations around voluntary agreements in the Harney Basin, as well as water use in the Mid-Columbia, may also be topics that various committees may tackle as well. But again, as I've said already, a lot of it's up in the air. We don't know, we don't have the full list of introduced bills yet, but we will be sure to come back to you and report back on the happenings of the 2026 session when we know more. So, the star of the show. In addition to prepping for 2026, we are turning our attention to 2027, which I know kind of sounds crazy given that we're still cooling off. I'm still cooling off from 2025. I don't know about you guys, but the prep for 2027 essentially starts a few months after the 2025 session concludes. So again, as I mentioned, this will be a long session, which means it'll run for about 6 months. This is when the legislature considers building biennial budgets. They're typically tackling larger policy bills. There's just more time to kind of explore those bigger sticky wicket problems. And then the legislature is also reviewing and considering amendments to agency key performance measures. I will note that the development schedule and instructions for themes for budget and legislative concept development does come from the Department of Administrative Services and the Governor's Office. We have not yet received formal instructions on budget or very specific timelines. So my talk today is going to be relatively high level based on our experience in past cycles and largely focused on the legislative agenda just because the budget process is kind of its own beast and we don't have instructions there yet that are typically going to be critical from our starting point when we develop our budget. So I'm going to give just a quick overview of LC development or legislative concept development 101 and budget development 101, just as a quick refresher to get everyone's brains thinking about it. But when we say legislative concept, we throw that word around. That's essentially the precursor for bills. So it's what we're working on before they're filed and finalized and essentially gets a bill number. And then we transition from talking about LCs to bills. And we all remember those numbers and they, float around in our head for 6 months. So typically what happens is a bulk of the work on ledge concept development occurs in 2026. So typically between January and April, we'll be developing LCs for delivery to the Department of Administrative Services and the Governor's Office in April for consideration. Ultimately, those are the final decision makers on which concepts move forward and which ones do not. So typically around April, May time, DAS will submit the concepts that have been identified to move forward to Legislative Council, another fun LC acronym. They'll get those submitted, so drafting on formal bill language can start. Typically, we have an opportunity to review what's been drafted in September and provide any feedback on changes that need to be made based on further work that we've done on developing the concept, including any kind of public engagement or policy work group efforts that we've been doing on the concept. But typically, pencils are down for introduced versions of bills in October, and in December, those bills will get filed for introduction, and then we're off to the races in January of 2027. And so any changes that we want to make to agency concepts after that point, we'll need to go through the amendment process. We don't get to change those. We'll have to kind of go through the formal process there in committee to make any adjustments to bills. Budget development process. Quick reminder here, there are essentially 3 phases. The agency request budget, the governor's recommended budget, and the legislatively adopted budget. The ARB is developed in early 2026 and submitted around end of July 2026. And this is the menu of options that agencies provide to the Department of Administrative Services and the governor's office of potential budget investments for the governor to consider. This does not need to be a balanced budget, but sometimes there will be themes or limitations that the governor's office provides in order to help their process. So if you recall, in 2025, there was a cap on general fund requests. So oftentimes, if we do receive instructions there, the ARB will be reflective of what those instructions are. But for the most part, it's a menu of options that we provide the governor to select from. So from there, the governor's office and DAS reviews the GRB, or excuse me, the ARB, and then they work to develop the GRB, which uses components from the ARB, governor priorities, current laws, and then revenue available. So again, that's a budget that has to be balanced. The ARB budget doesn't necessarily have to be. So when the GRB is published in December of 2026, it's usually December of the year right before the session starts. The GRB is the agency's starting point for negotiations with the legislature. So that will be our starting point for budget negotiations. The legislature typically starts with the GRB, reviews it, they'll hold public meetings, and then they'll often make changes and tweaks to the GRB based on a litany of things, including other relevant pieces of legislation that may have fiscal implications, other legislator priorities or initiatives that they want to fold into the budget, other reductions that maybe they need to make depending on whatever the revenue forecast looks like, things like that. And then ultimately they will vote on the final LAB. And that doesn't typically happen until the end of the long session, so in May or even June in some cases. So we're prepping now, but we likely will not know what the full suite of our budget will look like for about another 18 months. I will also note that further changes can be made in emergency board meetings or special sessions that ultimately rounds out what the LAB looks like. But we are a ways away from knowing kind of what the final look of our budget is going to be. So again, as I mentioned, we're still in the very early stages of legislative concept development, but we don't have a full list of items for you today, but we do have some general criteria that we are using to guide our work, and that we're kind of the filter that we're using to look at all the concepts that, theoretically we could run. So first, we're going to be considering concepts that align with an advanced strategic plan priorities and IWRS milestones. So that's been a big topic of discussion for this commission over the last couple meetings, is reviewing the strategic plan and then adopting the IWRS. So we are really looking to use those strategic documents to help function as scaffolding for items that we are going to propose for legislative work. We also are aware and cognizant of statutory sunset dates or results from court findings that need to be integrated into statute. So for example, the Deschutes Mitigation the Deschutes Mitigation Program is set to sunset in 2029. So that is an item that we are looking at and considering for potential 2027 topics of discussion. And then the last item is addressing any technical issues within a program and prioritizing those that have arisen from recent legislation. So not just in 2025, but there's been quite a bit of legislative and policy work done on a litany of programs, from dam safety to well construction, place-based planning, grants, water rights. And so we are aware that if there are errors or new items that have come up that need fixing to help better implement the program, we're providing space for any opportunities there that we may need to go in and make some adjustments to some of those programs. Again, once we have a more fleshed out concept list and a better idea of kind of where we're headed, we will be sure to report back. So just to wrap up, again, there's still a lot of uncertainty. I apologize for this presentation. We're kind of a couple months ahead of knowing where exactly a lot of these pieces are moving. But as always, we will be sure to report back on any efforts that we are embarking on for the 2027, 2029 ARB and legislative concept development process. We do expect that engagement for that with interested parties and tribes will begin in 2026. As I mentioned, that's kind of when the bulk of the work happens. So we're kind of right on schedule there, and we'll be sure to involve the commission with any updates as necessary. And then again, we will be sure to report back on any adjustments or policy developments arising from the 2026 short session. We anticipate that there's going to be some big conversations and big decisions that the legislature needs to make. And so we will be sure to keep you all apprised as we get more information. So with that, I'd be happy to answer any questions. Lisa's here, and as is Raquel. And again, very sorry we couldn't be with you in person today. I was really looking forward to it, but I am happy to answer any questions you all may have. Thank you.
Thank you so much for that update. And we changed the schedule on you, so you don't have to apologize. Just a clarifying question. You mentioned that we need to reduce by 5%, and you gave 3 main categories. Did I hear you correctly say that we're not looking to reduce staff positions?
Commissioner Smitherman, that's a great clarification. So I want to address 2 things. The first is that these are reduction options. We were not told to make any formal reductions. The legislature is the decision maker on that. So these are just options, and we were given reduction targets. So that doesn't mean that they're going to reduce 5%. They could, but it doesn't mean that they are. It doesn't mean that they're actually going to take any of our recommendations. These are just options. So I want to make that very clear. You can see in attachment 1, I think, of the staff report gives a more detailed list of the items that we put forward as options. And you will see at the very, very bottom, there are a few staff members or staff positions identified to get us up to those targets. But for the most part, you will see stacked on top of those a litany of things that are not staff. So we tried very hard to prioritize preserving staff because, again, they are our greatest resource in delivering services that Oregonians rely on. So I hope that answers your question.
It does. Thank you for clarifying that. Are there any questions from commissioners? Commissioner Mall?
Just one quick one. Will there be another economic forecast either before or within the short session that might influence those decisions?
Commissioner Mole, that's a great question. There should be. I don't know the exact date. Lisa may.
Yes.
Shake your head.
Yes.
Help me, Lisa.
Yes, Commissioner Mall. They just had a December forecast, and the next one will come out in the beginning of February.
Thank you.
You're welcome.
Other commissioners? Okay, I think that concludes at agenda item J. Thank you so much for your presentation, and we'll look forward to seeing you next time. Okay. I believe we still have a few more minutes. So I propose that we look at meeting minutes and approve the meeting minutes before we adjourn today. There are 3 sets. Set from September regular commission meeting. Then there was a special October 3rd meeting and another special October 30th meeting. If you've had a chance to look them over, I'll go ahead and entertain a motion.
I move that we approve all 3 sets of minutes as recorded.
Second.
We have a motion and a second. I'll go ahead and take a vote. Commissioner Mall?
Yes.
Commissioner Chiara?
Yes.
Commissioner Newman?
Yes.
Commissioner Lee?
Yes.
Commissioner Wolf?
Yes.
And I vote yes. Meeting minutes are approved for the September 2025, October 3rd, and October 30th, 2025 commission meetings. Okay, so That concludes agenda item L. So I think that we should probably adjourn there. It looks like the other items set for tomorrow will take a little bit more time. So as of now, I think that we've heard everything that we can today. And we can go. We did. We already did. Yeah, we already did. Item F was our open public comment period. We kind of mixed it up a little. So with that, I will go ahead and adjourn today's meeting and we'll reconvene tomorrow morning at 8 o'clock. That was a